persons. Living persons. The answer for the question 1 is A. So it has to take place between the living persons. Then TP Act shall be applicable. Sorry. Removable property. What is removable property? Removable property term includes land, benefits to arise out of the land, and things attached to earth, except, this is the definition given under the Transfer of Property Act. Grass, standing timber, growing crops and grass, standing timber, growing crops and grass. So you read the definition, it includes land, benefits arising out of land, and things attached to the land. So the answer for the question number 2 is D. Because standing crops, in one batch they asked why you exclude a standing crop, standing timber, growing grass and grass. Actually, this is a definition given by the Act. So if you want, if at all you want to make the correction, you have to do the correction. You have to correct the Act only and not the proper question. So it excludes standing timber, growing grass. Next is transfer of property. This is the thing. The transfer under TP Act. TP means Transfer of Property Act. So transfer by government, transfer by operation of law, transfer by the acts of the parties, none of the above. Transfer under Shada said C, Vijayalakshmi ma'am said C. Shada said C. So the answer for the question 3 is C, because it is a transfer by the acts of the parties. Land includes plain land, water land, building, wall fence, all of the above. So the definition of transfer of, in the definition removable property said is land, property attached to the land. Everything has to be treated as removable property. The answer for the question is, yeah, it is D. Benefits to arise out of land includes hereditary elements, right of way, lights, ferries and fisheries, the right to catch fish, right to collect rent and profits from immovable property, interest of a mortgagee in immovable property, minerals below the land. All are immovable property, whether the statement is correct or wrong. So the benefits which arise from the immovable property have also to be treated as immovable property. So the answer for the question is A. It is true. Now you read the question and do it patiently. All are immovable property. Sixth one is includes things rooted in earth, including trees and shrubs, except standing timber, grass and growing grass, because standing timber, grass and growing grass have been exempted from the definition of immovable property. Trees, if removed, it should be treated as movable, otherwise immovable. So this is a question whether the statement is true or false. Trees, if it is removed from the land, whether that tree is to be treated as movable or immovable. It is in the statement is correct because trees are rooted. When it is rooted, it is immovable. When it is chopped, it becomes movable property. So the answer for the sixth question is true. 7-1. This is the basic thing which needs every person attention. Number of witnesses required for attestation. How many witnesses should be there? Is it 3, 1, 2, or 2 or more witnesses? In documents, you have to write. Normally, it is 2. Whenever you are seeing any document, it is 2. But the Act says it is 2 or more witnesses. So any number of witnesses can be there for any document. So the answer for the seventh question is D. Number eighth question is defective in witness make the document as valid, defective, nothing is going to happen to the document, none of the above. Because there's only a defective in witness. Whether the witness defective in witness make the document as defective. This is the question. See, out of 3 or out of 2 witness, one has not written his father's name, or one has written the his name and the wrong thing. Suppose whether the question is whether the witness, if it is defective, whether that witness, defective witness, make the document defective or not. The answer for the question is 8B, because defective in witness make the document as defective because it cannot be enforceable before any court of law. Suppose if any witness is defective, suppose if he call to the court to say about his witness, then if the document itself is, witness itself is defective, then the document is also defective. You can't enforce before any court of law. Which one is false in kinds of notice? Actual or express, constructive or implied notice, imputed notice, none of the above. Which one is false? See, here you have to be very, very careful whether it is true or false. Here it is false. See, actual notice is there, express notice is also there, constructive implied notices are there, imputed notice are also there. So which one is false? It is D and not C. Actionable claim means, so you have to initiate some, you have to make the claim. So a claim to be unsecured on debt, a claim to be beneficial interest in movable property, not in possession of the claimant. So the definition of a TP Act for actionable claim is C, A or B is the answer. The definition of TP Act for towards actionable claim is a claim to be unsecured debt or a claim to beneficial in movable property, not in possession of the claimant. This is one more question in the examination. In debt, money is certain, otherwise it is not a debt. Whether the statement is true or false, or partly true or partly false. I owe you 10,000 rupees. That means the term, the loan should be expressed only in money and not in other terms. I owe you 500 bags of rice. So that is not a debt. So here that in debt, money is certain, otherwise it is not a debt. The answer for this question is A. Here, the following are False actionable claim. False. Claim for arrears of rent, claim for money due under insurance policy, return of earnest money, a share in partnership, maintenance allowance payable in future, fixed deposit in bank. The above are not actionable claims. So which one is correct? Uh, Jalashmi ma'am said D. Purushottam sir said D. Shalini ma'am said C. So, ma'am, Shalini ma'am, you go to the bank, make a deposit of 1 lakh, don't make the claim.
No, I was confused in the first line, maintenance allowance payable in future.
Yeah. It's your right, na? See, in maintenance future, in divorce, it is your right. You can claim. So you make a deposit in bank, don't claim. So the answer for the question is
D.
D. Within what date actionable claim has to be taken into account the liabilities and equities? Before 15 days, date of transfer, after 20 days, after any date of transfer. B. Arun sir said C. Jalashmi ma'am said D. B. C. The actionable claim comes into effect only on the date of transfer, on not before that and after that. So the answer for the question 13 is B. For instruments which are negotiable or mercantile documents, whether the provisions of TP Act is applicable, yes, no, it is applicable. The answer for in the definition part of TP Act, they say that instruments which are negotiable mercantile documents, for that also TP Act is applicable. So here, living persons. So this definitely this is going to be one more question. In suppose we are going for 4 attempts or 5 attempts, then you will find in one paper this question. Because I got the experience, because I went for some 7 attempts, so I know the questions also. Living persons includes, it's an inclusive definition. Human being only, who is an individual, company, AOP, body of individual. So answer is 16D, because it is the question is it is inclusive. So living persons is the definition. TP Act covers the transfers between two living persons who are human beings, dead or alive persons, two dead persons, none of the above. The basic definition of Transfer of Property Act, it is applicable between the living persons. So the answer for the question is 16A. So that's why initially I said it is applicable for between living persons and immovable property. So you have to visualize and do that. I mean, give the answer.
So who are human being doesn't make any difference.
Huh?
Who are human being doesn't make any difference, because there can be transfer between
Inclusive
company
definition. It is inclusive definition.
Okay.
So company, body of individual, firm, individual. Here in this question, it is a transfer between two living persons. There cannot be a transfer between a dead person and a alive person. Two dead persons, you cannot make a transfer. Which statement is false? Again, once again, I'm telling you this. For this, you have to give the answer. The following kind of property is not transferable: pension, restricted interest, right to re-entry, public office, any kind of property which is not prohibited by law. So pension, for general information, I'm saying pension you cannot transfer to anyone. Restricted interest you can't, maintenance you can't transfer. So right to re-entry you can't transfer. Mere right to sue untransferable. Public office you cannot transfer. The question is which one is false. So which one is not which one is transferable? Nothing. ABC is ABC are not transferable. The question answer for the question 17 is D is the answer. So pension you cannot transfer to anyone. Public office you can't transfer post office to Purushottam sir. So you can't transfer. So the answer for thing is which is prohibited by law, you can't transfer. Here, which is not prohibited, that means you can transfer. So the answer for the question is 17D. See, here, regarding Transfer of Property Act, only few members have got experience. So this will be new to even charter accountants, new to charter accountant, cost accountant, everyone, even for companies. The company secretary, I think TP Act is there, but for others it is a new one. So that's why I'm going very slowly. But if you read, if you master in my MCQ of this 73 or 74 MCQs, then you will be a master in TP Act to the extent of 50% or 60%. So a right to future maintenance under TP Act cannot be transferred, can be transferred with court permission. No such thing in the Act. See, a widow is that the court said you have to give a future thing of say 10,000 rupees. That lady, she cannot transfer her future maintenance to anyone. So that's a future maintenance. So the answer for the question number 18 is A. So future maintenance rights cannot be transferred to anyone. Legal incidents also include machinery attached to earth and movable parts thereof. Only movable parts, only machinery, none of the above. So anything attached to the land will be covered by the Transfer of Property Act. So question number 19 is A, because it is attached to the earth and movable parts thereof. Oral transfer is permitted in case of immovable property, gift, transfer of actionable claim, lease, sale of property, none of the above. See, one basic thing we have to remember, movable property, say if it is a car, just by simply handing over the key to the other person, that means car is being transferred to the other person. For movable property, orally you can transfer, but with reference to immovable property, everything you have to go and register, then only immovable property can be transferred. So oral transfer is not permitted in the case of immovable property. The answer for the question number 20 is E. Sorry, here I have put 21. It is 20E is 20E is E. E is the correct answer, because for gift you have to go and register. Actionable time you have to go and register. Lease deed you have to register. Sale of property you have to register. Because oral transfer you can't do. You can't. Immovable property cannot be transferred by way of oral transfer. It has to be registered before the registrar of. The following are transfers as per the TP Act. This you can easily answer. 21. Yeah. It is B. B is the correct answer. Because all A, C are included in the definition. B. D is not applicable. See, first thing, just like in Crorepati program, first you have to eliminate the common thing. Then you have to choose between the remaining two or remaining three. The following are amounting to transfer as per the TPR. Partition, charge, relinquishment, surrender, easement, will, compromise, family arrangement, and family settlement. All have to be treated as transfer. So the answer for the question number 22 is D. Yes, here I think you can easily give the explanation. The following are competent to transfer. Central government, every person competent to transfer, minor, any one of the above. Competent to transfer is not any, Shada ma'am, I think Purushottam who said, Shalini ma'am, it is not everyone. I mean, it's not minor, you cannot transfer. So the answer for 23D is wrong. Because 23B, every person competent, says central government is also competent. Here the definition says every person. So every person is competent to transfer. Minor it cannot be is not a person to transfer. So any one of the above means, that means it is minor is also included. So the apt answer for 23 is B. Transfer by persons before they acquire interest is possible in the following cases. Transfer. So tomorrow I am going to win 1 crore in lottery. Can I transfer that amount today? No, it is not possible. So Hindu and Muslim can say I am going to get a right in that property in future. No, I cannot transfer that property now. Say tomorrow through my, I think my father, he will give me a will that I am going to get this property. Now I am going to transfer the property. Is it possible? No, it is not possible. So the answer for the question number 24 is D. This you can read, and this is also one more question in the examination. This you can read and give your answer. Yes. See, I have acted on good faith. As on the date, I'm not the owner, but in future I got the right over the property. So I have to automatically hand over the property to the buyer. Here X is an unauthorized person. He transfers his property to Y, and Y accepts the same in good faith. After that, only Y came to know that X has got no right to transfer. Later on, X has acquired the right. Whether Y can attain the title over the property, because after that he has got the right. So here the answer for the question is D. Yes, Mr. X has to hand over the property to Mr. Y after become owner, and Mr. X has got no right to cancel the transfer because the Y has acted on good faith. So the answer for the question is D. So here another portion, another part of transfer I am going to explain. That any transfer with absolute restriction you cannot do, but with partial transaction you can transfer the property. This is a basic concept for another 5 to 6 questions. Here now you read the question. Mr. Ram sold the property to Mr. Kumar with the condition that Mr. Kumar will not sell the goods to anyone during the lifetime of Ram. Is this sale with condition is allowed? I am saying that you cannot transfer the property. I have sold the property to you with the condition that you should not sell the property till I alive. It is absolute restriction of the rights over the property. So this type of transfer is not allowed. This type of transfer is said to be void. A transfer with partial condition is allowed. Here he is fully restricted. No, you are not supposed to sell to anyone. So the answer for the question is no, it is not allowed, as this type of sale is void. It is there in the TP Act, Transfer Property Act. So same thing they are saying. The sale with absolute restriction is to be treated as void. With partial transaction, partial restriction, you can do it. Next question is, Mr. Ram sold the property to Mr. Babu with the condition that the property should not be gifted to anyone by Babu. Is it a valid transfer under TP Act? Yes, yeah, he is not supposed to give only gift, but he can sell, he can mortgage, he can do anything other than gift. It's a partial restriction, so it is valid by law. So sale, transfer with absolute restriction is void. Transfer with partial restriction is valid. So the answer for the question number 27 is C. Moving to question. So what are some examples I have given? Partial conditional transfer, a condition that the property should not be transferred to a particular person. So you can transfer to anyone but Mr. X. So it is valid. It is valid by law. Sell back only to the seller and not to anyone. I am selling the property to you. You have to sell the property only to me. It's an absolute restriction. It is void. Then a compromise by way of settlement, though the restraint clause is there, it is valid because it's a family settlement. It is valid. Lease agreement, and normally when you are taking any audit or assignment, they say that you are not supposed to let your audit assignment to someone. It amounts to sublease. So lease agreement is that, but in the lease agreement there is one clause say that you are not supposed to give to any sublease. Then it is valid by law. Then transfer of property to married woman, not to transfer to Muslim or Buddhist, is valid as it is partial condition of transfer. So I have transferred property to a married woman and with the condition that the property should not be transferred to a Muslim or Buddhist. That means for other community, for other religion, you can transfer. It's only a partial restriction. So it is a valid transaction. These are some partial conditional transfers I have explained in question number 28. 29. Mr. A transfers absolute interest without free enjoyment in the property to Mr. B. He restricts enjoyment of B with the condition that is the transferee property who takes absolute interest cannot be restrained in his enjoyment or disposition. So now I am handing over the property to you, but you are not supposed to enjoy it. It's absolute restriction. So it is void. The answer for the question number 29 is A. Because I have transferred the property, but you are not supposed to enjoy it. So it's an absolute restriction. So it is void. Exception to the right of enjoyment. Exception, see, the transfer may impose a condition that the transferee should not affect the enjoyment of the transfer of property by constructing a building. It is valid. So you enjoy it, but don't disturb my building. So it's valid. Next one is if any property is transferred to someone and say that the same property is given to some other person as guarantee, and in the case of failure of that borrower, the property may not be taken as security for insolvency, and such transfer is invalid or not. Now I will transfer the property to you, but I am going to give this property as guarantee to take the loan, then you are not supposed to claim it. So this is not correct. So this type of transfer is invalid or void. Yes, this is another part of TPI. So far we discussed general, then sale with condition or restriction. Next one is unborn means unborn. Who are all called as unborn?
In existence in mother's womb.
In existence in mother's womb, not in existence even in mother's womb. Born with defects, above things are false. So in existence in mother's womb means the child has come to the earth. So that child is not called as unborn person. Not in existence even in mother's womb. That is called as unborn person.
Excuse me, sir.
Yes, sir.
Sir, could you please explain question number 31 again?
31 or 32? I am
31. We have discussed 32 right now. 31, the previous one.
If any property is transferred to someone and say that the same property is given to some other person as guarantee. So I have transferred the property to you. I have given the same property as guarantee for my loan to someone. And in the case of failure of that, the borrower of the property, suppose he has taken as the guarantee. In the failure, let them take the property. Say, I have transferred the property, that means you have got the absolute right. But I am giving the same property to some person as guarantor, as guarantee. So that is not valid transaction. It is called as void.
So what is the situation if the first person has taken it is in good faith?
Huh?
The person who has bought the property has taken it is in good faith and he was not aware of that guarantee?
No. This is all the cases which have been reported in TPI. Now it is not possible. Once if the transfer is over, see as per the latest rule, if once transfer is made by way of sale or by way of mortgage, everything, if at all, if you want to create any other charge over that property, you have to get no objection from the transferee, who is the present owner.
Right.
In this case, I have given the property. Simultaneously, I have given the property as guarantee to someone. In case of failure, let the person who has given the loan, let them take the property. It's not possible. So this type of agreement, this type of transfer is void.
So that means the transfer is void. The borrower can take the lender can take the property if the borrower fails to pay the money.
No. So I have transferred, Shada ma'am, I have transferred the property to you. Now you are the owner.
Right.
Now can I create another guarantee to someone?
No.
That's the thing. That type of transaction is void.
So that means the transaction of guarantee is void, the transfer is valid.
Transfer is valid, but
Transfer is valid, but
Okay.
giving, guarantee is invalid.
because here it is written such transfer is
Transfer is
invalid.
invalid and void.
So that was the confusion.
One person we have explained. This is not in mother's womb. Which statement is true? Property can be directly transferred to unborn person. Also for the benefit of unborn person. Property cannot be transferred directly to unborn person, but it can be transferred to the benefit of unborn person. Property transferred for the benefit of unborn person. Property cannot be transferred directly, as well as not for the benefit of unborn person. See, I have got a very good. I want to share my experience. See, next to my, I have purchased one house, and next to my property, there was a one house. In that old person, we used to call him as Tata. Tata means grandfather. In Tamil it is called as Tata, and I think, I don't know in Hindi. You can say grandfather. What is the Hindi definition?
Nana, Nana.
Nana. Okay. So what he did, he has written a will saying that this property is a sulfurite property. This through will he is writing this property can be transferred after my demise to my grandson's son. Grandson's sons. Okay, we know that I know that grandson of that Nana, or that grandfather. Out of that, he has got two grandsons. One is married, one is absconding. So he said, grandson's sons. That is, he has written a will to the unborn child. And if any child has come through that grandson, that is as son, not as daughter, then the right comes into the effect. So the answer for the question number 33 is, property cannot be directly transferred to the benefit of the unborn person, but cannot be transferred directly to unborn person, but can be transferred to the benefit of unborn person. In case if he comes in future, so this property can be enjoyed. So the answer for the question number 33 is B.
Sir, what is the difference between the clause A and B and the saying, because we are saying that my son's grandson?
See, the answer A is can be directly transferred to unborn person. A transaction should take place between two living person. Unborn person, a living person.
Okay.
Okay, now we come to point number B. It cannot be directly transferred, but can be transferred to the benefit in future. It can be transferred to the benefit of the unborn person. So this is the difference. Vesting of property absolutely cannot be postponed beyond lifetime of one person. See, any benefit can be transferred only to the lifetime, only to the lifetime and not beyond that. This is the basic thing. So the answer for the question number 34 is A. Vesting of property absolutely cannot be postponed beyond the lifetime of one person. See, this person is going to alive, and he will get the right only after his death. Is it possible? It is not possible. Simple language. See, any transfer can be done till the lifetime of the person. So the answer for the 34 is A. What is the maximum period of perpetuity to attain the property? It is as per the definition of TP Act. It is D, A or B. Born child after born attains 18 years of age. There is no maximum period. So suppose if anyone, for unborn child it is 18 years. For anyone there is no maximum period. So perpetuity can be transferred. The answer for the question 35 is D. Limit of accumulation of income in relation to the property. This is also in the TP Act rules. How to calculate up to the lifetime of the transfer or a period of 18 years from the date of transfer. Here, the answer is up to the lifetime of the transfer, A and B. So answer is C. So only this is stated in the TP Act definition. So how to calculate the income, accumulated income up to the lifetime of the transfer. Beyond that, suppose if is after transfer he lived only for 6 years and maximum is 18 years from the date of transfer. So the answer for the question 36 is C. what is contingent interest? Vested interest. An interest usually in land or money held in trust recognized as belonging to a particular person is vested interest. What is vested interest? An interest recognized as belonging to a particular person is vested interest. So vested interest, which is subject to any condition precedent, not subject to any condition precedent, when it takes effect immediately or on the happening of any event which is certain, when the event is happening of the event is uncertain, that means it is contingent interest. When the happening of event is certain, this is called as vested interest. So the answer for the question number 37 is D, B and C. There is no condition. You can get the property, but the happening should also be certain. So the answer for the question number vested interest 37D is 37 is D, that is B and C. See, after reading this, you go to TP Act. This will be useful to your practice also. You go to the TP Act, you just read the portion so that you can easily understand. A vested interest is defeated on the death of the transferor before he obtains possession, whether the statement is true, false, partly true, or partly false. So any vested interest on the date of, if he has died, whether that statement, whether he will obtain the possession, before obtaining the possession, he died. Whether the statement is true or false or partly true or partly false. So he died, but before taking possession. So that means the statement is true.
What is the difference between partly true, partly false?
To confuse you. See, I have prepared this statement. I have to give 4 answers, 4 questions. I have to give 4 answers. Here I have found out only 2. That is true or false. So I said it is partly true or partly false. So you will get confused.
So if there is an agreement between two persons that on the occurrence of an event which is certain, the property will be transferred to you. And before the occurrence of that event, the person who has transferred the property died. So it will this cannot be executed.
No, before your time, sir, vested interest provisions have been defeated. So before death, he has to obtain the possession.
Okay.
So I am going very slowly because TP Act is not well versed to charter accountants, even except for company secretary. TP Act is not well versed. So contingent interest here, this is very, very simple. You can easily understand and you can tell. Now you share your answer. Is the right to enjoyment which depends on happening of certain event which may or may not happen. That is vested interest. Happening of uncertain event which may happen. That means it's a condition. So this is also wrong. Happening of an uncertain event which may or may not happen. Happening of uncertain event which may not happen. So the answer for the question number 13 is C. Shada ma'am, it is uncertain event. Certain event means it's vested.
Right.
Uncertain means only contingent. In contingents, it may happen or may not happen. So I think this you clear, na? This is happening is C. Happening of an uncertain event. Certain event means vested. Certain means contingent. Here, in certain event, it will happen, but in uncertain, it may happen or may not happen. So that is called as contingent interest. In vested interest, owner's title is perfect, whereas in contingent interest, owner title is yet imperfect. whether the state is correct or false. C is yet imperfect. The statement is false because in contingent interest, the ownership title comes to you only when that event is certain. Only when that event happens, then only the owner has got the right. Just because it is contingent interest, the owner will not get any right over that property. So the answer for the question 41 is false. In, in vested interest, it is perfect. It is correct. In contingent interest, it is not perfect. It is yet perfect because the ownership title comes into effect only the event is certain. Otherwise, it is not. So the statement is false. Vested interest takes effect from the date of transfer, and in contingent, it happens on the happening of an event. Whether this statement is partly true, partly false, true or false. Vested interest on the date of transfer. In contingent interest, the right comes to you only when that event has taken place. The answer for the question is C. It is true. See, in examination, you just read the question patiently, then you know the answer. But in examination, they will confuse you. So please read the question very, very patiently. Then before submission, you have to recheck once again. And don't attempt the question which you don't know, because it is minus marks. And if you know only 40 questions, you can take the risk. But you can, if you attend some out of 96 questions or 90 questions, if you attend 70 questions, then you can remaining 20 questions. If you don't know the answer, play safely. Transferee here, transferee dies before taking possession. It is not defeated in vested interest, whereas it is defeated in contingent interest. Whether the statement is correct or wrong. A and B, B is a transfer. Before taking possession, he died. Vested interest means the happening is certain. So B has got the right. In contingent interest, the happening is uncertain. Only when the event has happened, then only the owner, that is B, has got the right. Now you can give the answer whether the statement is true or false. It is A. Vested interest is certain. It happening is correct. So vested interest is transferable, heritable, and heritable, nothing above. 43 is Shada said C, Vijayashmi said C, Arun said A. Yeah, vested interest is transferable as well as heritable. Yeah, you are correct. You are partially correct. So just like statement, it is partly true. You are partially correct, but you will not be given half mark. You will be given -1 mark. So transferable and heritable. That is the answer. So 43C. Contingent interest. It is transferable, heritable, and heritable, not clear. Arun sir, whether you say that the question is not clear or... Oh. The answer is C. Say vested interest, it is transferable and heritable. Contingent interest, only when the event has come, then only you can transfer. So it can be transfer. So the answer for the question number 44 is 44A. I think Purushothaman sir also said not clear. Arun sir also said not clear. I think now you are clear. Immediate right must be present, but its enjoyment can be postponed in the case of immediate right must be present and its enjoyment can be postponed in the case of contingent interest, vested interest, property interest, current asset interest. So only in the case of vested interest, right is there, but it can be postponed. So the answer for the question 45 is vested interest. Unborn person acquires vested interest on the transfer for his benefit. After attaining 21 years of his after birth, on the date of born, after attaining 18 years of age after his birth, there is no such age limit. So unborn person means a person who is not even in the womb of the mother. Now is born. So when the vested interest comes to the unborn person, it means on the date of the born, the right comes to that unborn person. See, next portion is pending litigation. So here, if any property is under dispute, you cannot transfer the property to anyone. This is the basic thing. And you have to file the case before court of law to settle the dues. Even if you present the case to wrong court, this court will transfer the case to the exact jurisdiction court. Then only the case, that transfer is also allowed. These are the basic thing with reference to lis pendens. Lis pendens means pending litigation is the answer. Then cases pending in any court against the right to own the property, transfer of property is invalid and the transferee has got no right to own the property, whether the statement is true or false, because the case has already been pending in the court. You cannot transfer the property. If you transfer, whether the transfer is invalid or not. If the whether the transferee has got the right to own the property, now this is the explanation. So the statement is true. During pendency of any suit regarding the title of property, any dash interest in respect of that property should not be created. Old interest, existing interest, new interest, or new and old interest. There is already cases pending before any court of law. Can you create any new interest over that property or existing interest? The answer for the question 49 is C. A property which is subject to litigation, the case is present to a wrong court, whether the doctrine of lis pendens is applicable. So instead of filing to A court, the case is being filed to B court. Whether that type of filing makes the transaction invalid. This is a basic thing. See, if you have presented the case to wrong court, then this wrong court can transfer the file to the correct court. So this does not make the document as defective. So the pending litigation continues. So the answer for the question 50 is B.
So can we go back to question 50?
Yeah?
Question 50, sir.
Huh?
Can we go back to question 50, sir?
51 or 50?
50, 50, 50.
50, okay. See, I think you are a charter accountant, na? You are a
No,
charter
sir, I'm
accountant.
company secretary.
Company said, okay. Instead of filing the case before Coimbatore ROC, you have filed the case before Bangalore ROC.
Right.
This Bangalore ROC, he will transfer the case to the correct jurisdiction.
So the doctrine will be applicable or not applicable?
No, the doctrine of lespendence means whether this document, this type of wrong filing makes the case as failure. No, it can be transferred. Instead of filing before Bangalore ROC, you have filed before Chennai ROC. So Chennai ROC, they will transfer the case to Bangalore ROC.
Okay.
So doctrine of lespendence is applicable. Transfer by person who was not party to the suit. See, some PPT, some points, some 5 or 6 PPTs I will skip. Important thing I will discuss. Performance is valid if there must be a contract. So the consideration should be passed. Question must be in the hands of the transferee, and the answer for that question is all the above. It is not past performance, it's a part performance. Doctrine of part performance is not applicable in the case of immovable property, movable property, all property, because TP Act is applicable only for the immovable properties. So the answer for this is not applicable to movable properties. This you will get one more question. I can share, suppose we are going for the 2 attempts or 3 attempts. This question you will find. What is the minimum registration of the instrument value? 500 rupees, 1000 rupees, 100 rupees, 1 lakh. See, if you go to the registrar, if the property value exceeds 100 rupees, you have to pay the stamp duty. If the property value is less than 100 rupees, you need not pay the stamp duty. So the answer for the question 54 is C. This is one more question, and one of the papers, not only here, in IP also I find the same question. The following are intangible immovable property. Land and building you can see, furniture you can see, stock you can see, but you cannot see the right of ferry or fisheries. So the answer for the question number 55 is B. Dash interest passes to the purchaser in the case of sales. Bank interest, absolute interest, more interest, no interest. It is absolute interest passes to the purchaser in the case of sales. So B is the correct answer. In sale, the consideration is dash, whereas in exchange, it is another dash or anything of value. This you can answer. Give the answer. 57. In sale, the consideration is money, whereas in the exchange, it is property. So the answer for the question number 57 is C. There are 4 types of mortgages. Now we are going to discuss about the mortgage. There are 4 types of mortgage. One is usufructuary mortgage, English mortgage, simple mortgage, anomalous mortgage. There are 4 types of mortgage which we are going to discuss here. In mortgage, there is only an interest of the, see, in mortgage, only interest is being mortgaged in the case of immovable property. What is simple mortgage? So these 4 things you must remember, because this will be useful to your practice also. Here, the possession is being retained by the mortgager. But this mortgager said that I will repay the loan. But if the mortgager, the person who has failed, who has borrowed the money, has failed to repay the loan, then the person who has given the loan, whom we have to call it as mortgagee, has got the right to sell the property. Here, possession is retained by me. I'll say that I'll give the amount. On due date, I have not repaid. Then mortgagee has got the right to sell it. So the answer for the question is D, all the above, because this is called a simple mortgage. So mortgage by conditional sale. What is conditional sale? The mortgage on default of payment of mortgage money on certain date, the sale must be certain, and on payment of loan before due date, and the sale is done after the date, then the sale is said to be void. Because within 2 years, I'll repay the loan. But on due date, I have paid the amount, but the person that is mortgagee, if he has sold the property after the receipt of his loan amount, then that sale is deemed to be a void one. So the answer for the question number 60 is yes. Yes, it is void. Very, very simple. On the due date or before due date, the person who has borrowed the loan repaid the amount, but the person who has given the loan has sold the property to someone, then that sale is to be treated as void. Now, this is the character of usufructuary mortgage. First thing we discussed about simple mortgage. There I have retained my possession. On due date, I'll repay the loan, but I have not paid it. So in that case, mortgagee has got the right to sell. In usufructuary, possession is delivered to the mortgagee. Then mortgagee, after receipt of the possession, he can receive any amount from that property and adjust that amount towards interest or principal, and no personal liability. The mortgagor has got no personal liability to repay the loan. So since I have handed over the property, every benefit is getting from the property, then the mortgagee has got no right to sell it. Then he has got no right to foreclose the loan. He has got no right to sue. So this is the difference between simple mortgage and usufructuary mortgage. The answer is D. This is correct. But this is the thing you must understand. Possession is handed over. Whatever benefit is that, you receive it. You adjust towards loan and interest. You cannot sue the case against me. This type of mortgage is called as usufructuary mortgage. That is, hand over the property to the person who has given the loan. The third one is English mortgage. What is English mortgage? Here, I want a loan. You are giving the loan to me. What I will do, I sold the property to you, and when I settle the amount, then you have to resell the property to me. In Tamil, it is called as ediradi sale. That is, I sold my property to you, but you are I am enjoying possession and everything, but the title only transferred to the person who has given the loan. When I settle the loan, he has to transfer the property to me. The mortgagor has to repay the loan on certain date. Mortgage property transferred absolutely to the mortgagee. Absolute transfer is made with the condition that the mortgagee has retransferred the property to the mortgagor. The loan is repaid. Whether the above characteristics are true. Yes, it is true in the case of English mortgage. So, simple mortgage we discussed, usufructuary, English mortgage. All these mortgages which have not been covered are called as anomalous mortgage. Here, deposit or title deeds are the basic items to be done under equitable mortgage. See, here I want to ask one question. EM is valid for how many years? EM means equitable mortgage. EM is valid for how many years? When you are going for bank audit or when you are going for any document verification, even suppose Shada ma'am is a company secretary, you can ask the company whether you have created any equitable mortgage with a bank. Now, my basic question is, for how many years EM is valid, equitable mortgage is valid? What is the difference between memorandum of deposit of title deeds? What is, between MODT or equitable mortgage? See, equitable mortgage is valid for 12 years. MODT is valid for lifetime.
Lifetime. It is renewed. It is renewed from time to time.
No, MODT need not be renewed, but you have to go to the registrar, then create a mortgage, then write a title deed that the properties are with me. So that is called as memorandum of deposit of title deeds. Equitable mortgage is being created at the bank itself. So validity is for 12 years. So here, deposit of title deeds are the basic item to create equitable mortgage. Yes, the answer is yes. One second. So other than other mortgages, that is called as anomalous mortgage. It's not a simple mortgage. It's not a conditional sale. It is not usufructuary or English mortgage or MOT. And the answer for the question is all the above. Can an immovable property under the Transfer of the Property Act be pledged hypothecated mortgage? So pledged means jewels can be pledged, cannot be mortgaged. So it's movable. Hypothecation is the word used towards the vehicles transport. Mortgage is relevant to the immovable properties. So the answer for the question number 65 is C, can be mortgaged. Consideration is present and future in the case of sale, mortgage, contract to sell, hypothecation. In sale, once you sell the property is not. So consideration is only present. Contract to sell, it is for the future. Hypothecation is also for the present. So the consideration for present I'll give the loan, future you have to repay the loan. So the answer for the question number 66 is B. This is called as mortgage. So here the explanation given towards anomalous mortgage. A mortgage is created where the mortgagor personally agree. There is no agreement. You personally agree to repay the loan, but I will not deliver the possession to you. Then this type of mortgage. So I personally agree that I will give the property to you, but I will not deliver the possession. This type of mortgage is called as anomalous mortgage. The answer for the question 67 is D. See, in lease, you cannot, you can use it, but you cannot enjoy the immovable property, because I am saying that I am the owner. You can't do the enjoyment. But in lease, the consideration is fixed. You have to pay the rent and everything. The duration of the lease is certain. Then acceptance of lessee in lease is also certain. So the answer for 68 is A. So he cannot enjoy, a right to enjoy the immovable property is wrong. So the answer for the question 68 is A in case of lease. Now, see, right, I think you know it, lease with reference to lease, it's a lessor, lessee. It is for a fixed term and it has to be registered. If there is a, whatever the conditions stated in the lease, they have to follow. This is a basic thing with reference to lease. And with reference to gift, you can make the gift with reference to movable and immovable properties. It should be in existence. A gift should be made voluntarily and without consideration. A good gift should be made with inter vivas. That is only between living person you have to make the gift. Donor must be competent to make a gift. That means a minor cannot be in a position to make the gift. Gift of future property is void. In future, I'll get the right from my father. Then I am going to give the property to you. That type of future transfer is, and the gift is void. So a gift of immovable property can be valid only if the registered instrument is signed by or on behalf of the donor and duly interested. I already said any immovable property has to be registered. Otherwise, that oral transfer is not permitted in the case of gift immovable property. Then, in case donee dies before acceptance of the gift, then that type of gift is void. So that means any death has occurred before taking possession, then that type of transaction is invalid or void. And registration of gift is needed if the value of the property exceeds 100. This we have already discussed. Minimum value is 100 rupees. Then a gift of property can be made by simple movable property can be made by simple delivery. Suppose you are having a mobile and it's a movable property. Just suppose Purushottam sir has handed over his mobile to me, then that's a transfer. That's a gift. I think Purushottam sir will not give his mobile to me as gift. But anyhow, for example, I am telling you. Then gift should be made for lawful purpose. Yeah, gift cannot be cancelled unless the gift is made by coercion. Okay, now who has got the right to cancel the gift? Can anyone tell? It's a very, very important thing. A gift once made to any person voluntarily without consideration, then it cannot be cancelled. But who has got the right to cancel the gift?
The person who is giving the gift.
No. Actually, this actually I have given the property to you, but you are not taking care of me because old age people they are gifting the property. They have to make application to district collector. So this district collector on inquiry, he found that it is done by coercion, or if it is done against the interest of the donor, then the collector can cancel the gift settlement. Not before court of law. Arun sir, receiver is no receiver. Shani ma'am, it is not court of law. It is the because district collector is head of the all government department of particular district. He has got the right to cancel. So because why I am telling this, suppose if anyone comes to you for consultation, a gift cannot be cancelled, okay, but it can be cancelled if you prove that it is being obtained by coercion. See, if in that case, a gift can be cancelled, but cancelled by the district collector. That is, even if the donor, the person was given the property as gift, I'm the donor, then I can cancel the gift, but this cancellation has to be approved by the district collector. What is universal donee? So I have transferred here all movable all assets as well as liabilities. So this type of gift is called as universal donee gift. Gift and the Transfer of Property Act is not applicable to Mohammedan gift, hibab. Hibab, I think only will is not possible, gift is possible, it is applicable. It's not applicable, it is applicable. Gift under Mohammedan law is allowed. So actually it is not applicable, it is applicable. Hibab, that type of transfer is called as hibab. So it is applicable. Gift under Transfer of Property Act is applicable to Mohammedan law. But a Muslim cannot write a will to his share. And what is the percentage of, suppose, in the general interest I am telling, You got a Muslim client, he comes to you. Father has got the self-acquired property. In Hindu law, the self-acquired property, I think you are the person is he has acquired the property on his own. That type of property is called as self-acquired property. If he died after writing a will, he has to follow the will. The person who, as per the will, it has to be acted. Suppose without writing a will, a self-acquired property, owned by the father, he has died. What is his share? That you can tell. These two things. One is for Hindu law, one is for Mohammedan law. What is the share of percentage? A Hindu, he has got self-acquired property. Without writing a will, he died. The legal heirs, what is the extent of share that legal heir will get? All the legal heirs will get equal share. That is, wife, one share. Suppose he has got two sons, then three daughters. So the entire property has to be divided equally between the legal heirs. In interstate, death certificate is, you have to produce death certificate, then legal heirship certificate. Then in the, as per the legal heir certificate, the total property of the person who has died without writing a will, then that property has to be divided equally among the legal heirs. Whereas in Mohammedan law, male has got two share. Suppose he has got two daughters, three sons, and wife is also there. So there are four ladies, two male members. So each male member has to put two share. Then ladies, they will get one share. That is 2 plus 2 plus 4. 4 plus 4 is 8. So you have to divide the total property divided by 8. 2 by 8. That is 1/4 share goes to one son. Another 1/4 share goes to another son. Then remaining thing is 1 divided by 1/4. That is 1 by 8 to other remaining ladies. So this is the way in which Mohammedan properties have been divided. In Hindu, it is equal share. So because this will be useful to your consultancy, in Hindu, it is used, equal share. In Mohammedan law, male members have got two share. Suppose 5 male members are there, 2 into 5. So totally 10. Ladies are 4. So 4. So total property is divided by 14. So 2 by 14, 2 by 14, 2 by 14, and 1 by 14, 1 by 14. In that manner, Muslim property is being divided. So this is with reference to the Transfer of Property Act. I'm just winding up Transfer of Property Act. I'm moving to the Stamp Act, and definitely I'll share this PPT to you. And my request to the fellow participants, please go through the Transfer of Property Act. After reading this, you go to the Transfer of Property Act. It's an ocean. It's an ocean. So though I have prepared from the examination angle, from the practice angle, you just go through the TP Act. I'm going to start with Indian Stamp Act. Here, I want to say basic things that comes to Stamp Act. One is stamp duty. Stamp Act is being fixed as per the Parliament thing. Central government has got some powers. State government has got some powers. Who has got central government? What are the things to be covered by central government? What are the things to be covered by state government? That's the thing we have to see. So the first question is, law and stamp duty with reference to stamp duty can be made by who has to create the stamp duty? The state government, parliament, home ministry, ministry of corporate affairs. So any act, it has to be passed only through the parliament. So basic thing. So law and stamp duty with reference to stamp duty can be made by the parliament. So the answer for the question number 1 is parliament. Now they have divided the fixing the stamp duty rates between central government and state government. So each state government, they have to form their own stamp duty, and it is applicable only for that state and not for other states. Suppose if Tamil Nadu has said that the mortgage fees cost is 5,000, it is applicable only within Tamil Nadu. It is not applicable to Karnataka. It is not applicable to Delhi. It is not applicable to Karnataka. Calcutta. But if central government defines a rate, it is applicable to entire India. This is the basic thing you must remember. Stamp duty rates with reference to bill of exchange, pro note, bill of lading, LC, policy of insurance, transfer shares, and debentures, proxies, and receipts have to be decided by. This is the power retained by the central government. All other powers have been given to the state. So stamp duty with reference to bill of exchange, checks, pro note, bill of lading, LC, policy of insurance have to be fixed by the parliament or central government. The answer for the question is B. So this is a basic thing. The rate with reference to stamp duty has to be fixed for bill of exchange. With reference to union territory, which comes under the state, which comes under central government, all the stamp duty powers have to be fixed by the central government and not by the union territory, because union territory has got no power to fix the stamp duty. Only the central government has got the power to fix the stamp duty with reference to union territory. In union territory, stamp duty on agreements, affidavit, articles of association, partnership, all other things have to be fixed by the parliament or central government. So the answer for the question 3 is A. So these are the two basic things. With reference to bill of exchange, powers of central government have been, see, you go to question number 2. This is the stamp duty powers retained by the central government. Bill of exchange, checks, pro note, bill of, these are the powers retained by the parliament. But when it comes to union territory is part of central government. So with reference to union territory, everything has to be decided by the parliament. So that's what thing. Here in union territory, stamp duty on agreements, affidavit, everything has to be decided by the parliament. Has to be so the answer for question number 3 is A. Dash has got the power to fix stamp duty other than bill of exchange, transfer of securities. Bill of exchange fix. This is nothing but state government has got the power to fix, because central government powers we already discussed, union power, union territory power we discussed. Other than the power, other than bill of exchange, other than check, transfer properties, the fixing the rate of duty with reference to stamp duty is be allotted to the state government. Then rates prescribed by the state government is uniformly applicable to all states. Your view on this point? Because Tamil Nadu has fixed one stamp duty, Karnataka has fixed one stamp duty. Whether Karnataka stamp duty is applicable to Tamil Nadu? No. So the rates are uniformly applicable to all states. The statement is false one. So you cannot, the rates is applicable only to the respective states and not to all. In union territory, who has got the power to fix the duty? State government, union territory, parliament, Delhi government. So Delhi government is a union territory. Goa is also a union territory. Who has got the power to fix the stamp duty with reference to union territory? It is parliament. The purpose of this is one more question in the examination. The purpose of Stamp Act is to raise revenue for. Why you put stamp duty? The purpose is to raise revenue for state government, central government, union territory, and government. So the answer for the question is it is government. So only to get the revenue for the government, the stamp duty is being fixed. Stamp duty fixed by the Tamil Nadu government prevails over entire district, entire state, entire other states, entire Indians. It prevails over entire state. Answer is 8. It is B. A dispute is there between state government and central government. Whose decision is final? There's a dispute between state government and central government. Whose decision is final? It is central government. The central government has actually delegated the powers to state government. Both the central government and state government can make law for various aspects of stamp duty other than dash of stamp duty. Central government, they can make their own law. State government, they can make their own law. But with reference to other than dash of stamp duty means that is rate. Rate has to be fixed according to the respective, because central government say that it is 2%, state government say that it is 5%. So rate, other than the rate, they can adopt their own law. But stamp duty rates have to be fixed by the respective central government or respective state government. Stamp duty is payable on those dash in the schedule. Stamp duty is payable on what? Not listed. There is a schedule is there, listed schedule and non-listed schedule. Those items who are all covered under, which are all covered under schedule are called as listed thing, and stamp duty has to be payable only on those items which are stated in the listed schedule. So with reference to question number 11, it is listed only you have to pay the stamp duty. In schedule, an item is not listed, so no stamp duty you have to pay. So in schedule, what is the levy of stamp duty on that item? It is A, because stamp duty is payable only on the listed items and not on the unlisted items. So question number 12, it is A, only nil rate. Instrument does not include stamp paper, documents, on-hand letter, will. I think this you can answer. An instrument does not include stamp paper, documents, ordinary letter, will. Arun sir said A. It is C. I think Vijayalakshmi said C. Purushottam sir said C. An ordinary letter is not an instrument. So the answer for the question number 13 is C. Dash draft of an agreement is not an instrument as per Indian Stamp Act of 1899. Dash draft. So actually for this, only when an agreement sign, it is called as an agreement. When it is not signed, it is not treated to be an instrument. So the answer for the question number 14 is unsigned draft. Though notarized, okay, it's a draft. Rough draft is also, it's not, rough draft is there, but only when the agreement is signed, then only it will be called as agreement. So unsigned draft of an agreement is not an instrument. So whether here, this is the definition of instrument. It is inclusive definition. It is not mean. So it's inclusive definition. That means everything you can include in this definition. The definition of instrument is inclusive. That is, this you can read. So it's an inclusive definition. The answer for the question number 16 is deed and instrument are one and the same, as both terms are used interchangeably. So what is your answer for this? Deed and instrument. What is the difference between deed and instrument? But they are said to be one and the same. Shada said C, Shalini said D. Instrument first, deed comes next. So deed is part of instrument. So instrument includes all. So it's a wider term than deed. So as both the terms are, no, instrument is wider than the deed. So the answer for the question 16 is C, because deed is part of instrument. Instrument is not part of deed. So answer for the question 16 is C. (17) A dash written on a paper, duly signed, sealed, and delivered, whereby an interest or right of property passes or an obligation binding on some other person is created. Instrument, deed, document, title deed. It is deed, a deed written on a paper, duly signed, sealed, and delivered. Then only instrument comes into effect. So it is then only if it is duly registered, then the obligation to pay the money is certain. So a deed, the answer for the question 17 is deed. So B is the answer. With the effect from 1/7/2020, this is the latest inclusion in the Stamp Act. With the effect from 1/7/2020, stamp duty on transactions in stock exchange has to be levied on cash, check, draft, electronic. This you can easily answer. In any stock exchange, it is only a electronic transfer. No cash, no check, no draft. So this is the latest amendment in the Stamp Act. 18D. A security created an interest and issued for the purpose of raising funds by dash is called as government security. State government, central government, union territory, or B. Any government can raise fund, but union territory is part of central government. So the answer for the question number 19 is D, A or B. So central government can raise its own fund and state government can also raise its own fund. The answer is D, 19. With reference to 20, a contract for the purpose of purchase and sale of a right or sell or right to buy and sell securities in future and including put and call option. For the 20th is D. So I am going little bit fast because here you will get only 1 mark, but in TP Act you will get 2 marks. Moreover, almost all you will get one question. I can say that you will get only one question in this, and if you master in my PPT, I think you'll be able to answer. A security capable of traded in stock exchange in India with effect from 1/7/2020 is called as. This is the effective definition from 1/7/2020. The answer for 21 is a security. See, you are listed a item in the stock exchange, but it should have market value. It can be traded, but without market value, there will be lot of securities which have got no market value, but it will be traded. So the answer for the question 21 is marketable security. The security should be marketable in stock exchange.
Sir, for examination purpose,
Sir? Yes.
Any cutoff date will be there. For example, this is recent.
No.
Yesterday.
You go to the IBBA site.
Yes,
You
sir.
see that that's an effective date from 1/4/2020. That's one syllabus. So any laws applicable up to 31/3/20 it is there. So I am just updating. This will be see once in I think another 6 months. After 6 months also they can change the syllabus. There's no cutoff date. See for this year it is assessment year 2021 in case of income tax. So because it is effective from 1/4/2020. If it is effective from 1/8/2020, so all amendments up to 1/8/2020 you have to take care. So you go to the IBBA site and under which category you have to write the examination. I think they have changed from 1/4/2020. So this 1/7/2020 is not applicable, but some people they may ask in the examination. So you have to be master. Here, a company has issued convertible debentures and never issued debenture certificate. After some time, the company has converted those convertible debentures into share capital and issue share certificate. The stamp duty has to be paid on debenture certificate, share certificate, first on debenture certificate, then on share certificate, first on share certificate, then on debenture certificate. This is a very good question, and it's also one more question in the examination. You can attempt. You can give your answer for this. I think Arun sir said C. First on debenture certificate, then on share certificate. Okay. What's your view on this? See, I have issued debentures, but I have not issued debenture certificate. Only when a certificate is issued, then only you have to pay the stamp duty. But I straight away issue share certificate. So I have to pay stamp duty only on the share certificate and not on the debenture certificate. So the answer for the question is share certificate. So stamp duty has to be paid only when the certificate is issued. So here it is share certificate and not on debenture certificate.
Sir, but in practical sense, sorry to interrupt. Sir, but in practical sense, when we approach to stamp duty department and there is a case of conversion of debentures into shares, they ask to submit the proof of payment of duty on debentures also. So is that wrong?
So Stamp Act says only when a certificate is issued, you have to pay the, it's only book entry. I'm doing it.
Okay.
So here, Stamp Act says only when a certificate is issued, you have to pay the stamp duty. Otherwise, not.
Okay.
Application money received on debentures. Now I am converting this debenture into share, but I am issuing only share certificate. But if I issue debenture certificate, then I have to pay the stamp duty. Decree of a court, is it a document, instrument, order, or direction? You can tell your view on this. A decree of the court is a document, instrument, order, or direction. It's an instrument. Decree, because instrument is a wider term. So you can include so wider term. So decree of a court is an instrument. This is the answer for this. Dash can be levied on decree of court. Court fee, stamp duty, stamp paper duty, on penalty. So decree of the court, see court fees, when you file the case, you have to pay the court fees. So decree of the court, it has, so you have to pay the, it has to be typed on the stamp duty paper, stamp paper, that is called as stamp duty. Stamp duty, the court, they will issue only on the stamp paper. So the answer for the question, though it is stamp B, normally stamp paper duty, there is no word called as stamp paper duty. It is only on stamp paper they have to issue the court order. So it is called as stamp duty. So normally in courts, they are using the word court fees and stamp duty. So the answer for the question number 24 is B, but there is no word called as stamp paper duty and penalty. So to get a decree of the court, no penalty can be levied. So you have to eliminate all other answers. So the answer for the correct question is 24B. A stamp duty on court order sanctioning amalgamation scheme can be levied by state government, central government, registrar of court, registrar of stamp. Who has to approve the amalgamation? Now, based on that, you can we can do it. So, amalgamation, High Court or NCLT, yeah. So here, court has got no power to levy stamp duty. Only state government or central government. So C and D ruled out. See, among the A and B, you know the stamp duty on bill of exchange, checks have to be levied by the central government. Other things have to be levied only by the state government. So the answer for the question 25 is A. Because the amalgamation, it is respect to ROC. So based on that, you have to collect the stamp duty. So amalgamation has to be approved by the respective courts. So scheme has to be approved by the respective court, but stamp duty has to be collected as per the direction given by the state government. It is not by the central government. So answer for that question is A. Sale by liquidator of a company's property attracts stamp duty as a sale certificate is issued by the official liquidator. Whether this statement is correct or wrong. So you are the liquidator of the company, you are selling the property, you are signing the sale certificate. So you have to issue the sale certificate. So whether the liquidator sale attracts stamp duty or not? This is the question. '26. I think you can say it is. Shada said it's B. C cannot be levied. So no. Sale na say any sale in any state, it has to attract stamp duty. So the answer for the question 26 is B. So see, liquidator is a person appointed by a court to carry out the liquidation proceedings. Any sale will be accepted only when the appropriate stamp duty is being paid. I think Arun sir is the right person to become our state revenue minister. And if you become revenue minister, then for no sale, no stamp duty. For sale, no stamp duty. So any sale, it's a basic thing. Any sale, you have to pay the stamp duty. Okay. Then in one of my friend, he's from Europe, he called me, sir, uh, he's a liquidator of under IBBA. I mean, he's an insolvency professional. He's an official liquidator. He sold the property, but in auction, the say registrar guideline is we can say 10 lakhs, but the auction property is only for 8 lakhs. For which rate I have to pay the stamp duty, whether it is for 10 lakhs or 8 lakhs. This you can share your view on this. Even without writing that, you can share your view. You can unmute yourself. You can tell your view on this. See, registrar guidelines. See, anyone has to pay the stamp duty as per the registrar guideline. Whereas in my friend case, through auction, that is the official liquidator, yes, auction the property only for 8 lakhs. On what rate you have to pay the stamp duty, whether it is 8 lakhs or 10 lakhs.
8 lakhs.
8 lakhs by Sharda. It is
10
on
lakhs. 10 lakhs, sir.
10 lakhs. Okay.
Guidance rate.
See, guideline rate is the market rate. Okay. When I do the correction, when do the auction, that is a market rate. So I have to pay 8 lakhs. But what this official liquidator is said, he did, he has recorded all his auction proceedings and forwarded to NCLT to get the order. NCLT says that you have to pay the amount only at 8 lakhs and not 10 lakhs. So still dispute is going on. That's why I raised this question. Still dispute is going on. Still it has not finalized. So whether it is on 8 lakhs or 10 lakhs, this is a dispute. But here I said it is 10 lakhs, but original sale was around 75 lakhs. 75 lakhs, registrar said that it is 1.25 crores. So he wants stamp duty on 1.25 crores. But he said, I auction only for 75 lakhs. I have to pay only for 75 lakhs. The case is still pending. NCLT say that you have to pay only on 75 lakhs because this is the market rate. This is the market rate. Only when guideline rate or market rate, which is less, you have to pay. In case normally what they say that market rate or guideline rate, whichever is higher, you have to pay. But when market rate falls below the guideline rate, the court says that you have to collect only for the market rate and not for the guideline rate. Still, case is pending. And thanks for your views on 10 lakhs and 8 lakhs. So the answer for the question is true. A machinery is attached to land. That machinery was removed and sold to other person by way of sale deed. The owner argued that no stamp duty is leviable as machinery is movable property. What is your opinion? Whether it's a conveyance to movable property, so stamp duty can be levied. Movable property, no stamp duty can be levied. Stamp duty can be levied only of immovable property. Sale deed is not an instrument, hence no stamp duty. So this is the answer. So here I have given the view on this. This is a court decision. An instrument which transfers either movable or immovable property is an instrument is a conveyance. For conveyance, you have to pay the stamp duty under the respective stamp. Respective states stamp act. An instrument which transfers either movable or, because you cannot. You have to pay the stamp duty if it is a conveyance, if you are writing a deed. It's a court decision. In that, they say that it's an instrument. So, the answer for the question 27 is A. Transfer of shares of cooperative society is a dash. Hence, stamp duty can be levied as it is conveyance, because name is being transferred. So it's this has to be treated as conveyance. So stamp duty has to be paid. Following purpose, stamp duty is leviable. Right to catch the fish in lake, benefit arising out of the land, it has to be treated as immovable property. So stamp duty has to be paid. Right to catch the fish for a period of 5 years, it is a lease agreement. So you have to pay the stamp duty. So stamp duty is payable on insurance policies and group insurance policies and C insurance policies. As per the government policy, you have to pay the stamp duty on this insurance policies. And fourth one is not there. Now, no stamp duty is payable on what? No stamp duty is payable on will, as the will comes into effect only after death. Normally, it varies according to state, but to register a will, you have to pay the minimum fees of 500 rupees in Tamil Nadu. I don't know about what about other states. In Tamil Nadu, you can, if you want to register a will, you have to pay 500 rupees. But can a will be registered or non-registered? A will can be registered or cannot be registered. Or is it mandatory or optional? You can tell your views on this. A will, whether a will can be on whether a will can be registered or not. Only a registered will is valid or not.
It's option.
It's an option. Arun sir said Vijayalakshmi said can be registered and optional. Yes.
But it depends on the value of property that is going to get transferred.
No, sir. Regarding will, it's only option. Even on a plain white paper, you can write a will, but you have to probate that will after the death before court of law. Then only when court approves, then they will send the unregistered will to the respective registrar office to transfer the right to the beneficiary mentioned in the will. Yeah, will can need not be registered, but will come into effect within a period of 1 year from the date of death of the person. Then only it can be probated. Only when you probate the will, that comes into effect. Even sometimes court permit, even after 3 years, if you find a will copy, you can go to the court, you can get it corrected. So only when the will is probated, you cannot go and directly surrender to registrar office. You have to go to the court, probate it, then court gives direction. So within 2 months, 3 months, you will get the order. So based on that, if there is any dispute, there is no dispute, then it can be registered. Another question, whether nominee is there for a deposit for a share certificate, but it comes into effect after the death of that person, and legal has also there. Which one comes first? Which one has got the right if the nominee is mentioned, whether the legal has or nominee? And then Govardhan sir, you can say. I think you are also on some other duty.
No, sir.
No, actually, my question is option.
No.
That is, nominee is there in share certificate or in deposits. The person was without writing a will, he died. legal heirs other than the nominee persons, legal heirs also there. Who has got the right over that share certificate or deposits? When nominee is there, nominee has got the right. When nominee is not there, then anyone that is legal has have got the right. Another question in nominee: can a nominee be a relative or not? This is another question. Suppose Purushothaman sir is depositing say 10 crores. So Purushothaman sir is depositing 10 crores. Then he makes me as his nominee. I am not a relative to Mr. Purushothaman or Govardhan or Arun. Can a nominee be appointed other than the relative? See, this
Yes,
all
sir. But
yeah.
sir, in case of immovable properties, I heard that of late, certain litigations crop up because of this nominee and legal heir. Because
No,
the
see,
old age people, they try to transfer the property in the name of in the name of a nominee who takes care of them. And finally, when the legal heir comes, they raise the issue. It's fraudulent. So
sir, the nominee portion is applicable only to movable property and not to immovable property. One. Second thing, with reference to immovable property, either it can be transferred through will or gift. During lifetime, it can be transferred through will. I mean through gift. After death, it is will. Even without writing a will, if any person dies, then the beneficiaries, that is all legal heirs, have got equal rights as per the Hindu Succession Act. With reference to Muslim, they have got male members, they have got 2 shares, and lady women members, they have got 1 share. But with reference to movable property, nominee classes are applicable. So this is a basic thing. If there is any nominee, then as per the nominee, you have to you can take the right. If there is no nominee, then legal has comes into the effect. I can create dispute. I can create a, see, Purushothaman sir, though we are not relatives, but he can give his 10 crores to me as a nominee. But nominee role comes into effect only after the death of the person. So during the lifetime of the depositor or shareholder, they can transfer, they can nominate anyone. They can cancel my nomination, they can appoint anyone. So this is a rule with reference to nominee.
sir, again, with respect to banks, normally after the demise of a person, if we go, okay, if a nominee goes, will they insist on a legal heir certificate and that certificate,
No.
or
If nominee is there, I have to prove my KYC, that's all.
okay.
If bank disputes, you can issue notice to him that from the date when I claimed, you have to pay 36% interest to me. You can go ahead because the manager has, that's why in any deposit receipt, they are saying that nominee is registered. So nominee is registered in the nominee column. Whether he is a relative or not, everything is written. What is the relationship between the depositor and the nominee? Everything is there. What is the nominee's age? What is the nominee's address? Everything is there. Only thing I have to prove that I am the Ravindran. So I have to prove that I am the Ravindran mentioned in the deposit receipt as a nominee. I have to prove my KYC. So the system weakness is, so I am V Ravindran, you are also V Ravindran. If you prove it, then you have got the right. But that's why they said that what is the nominee's address? Everything they say. Okay. In case of change of the name of the company, because instead of A Limited and B Limited, for that there is no stamp duty. Is it correct, Shada ma'am? Shada ma'am?
Yes.
No
Yes, sir, it is correct.
payable in case of change of name of the company.
Yes, it is correct.
Instruments executed on behalf of a government of in favor of government. It's a temple case. I am going to uh, uh, explain this case. I need. Can we break for 10 minutes and come back?
Yes, sir, we can do that, please.
Because my wife has already sent a message. Coffee is ready.
Oh, sir, you take break according to your wife.
See, now who is controlling me? You just imagine. And she's ready. Okay, okay, I'll come. Otherwise,
Ah, yes,
she will
yes,
go to
yes.
sleep. No, no, she will go to sleep and say, you put it on yourself and eat it.
Sir, you did not ask us to go for a break. You need to ask your wife.
Okay, I'll come back. Now time is 4:35. 4:45 will come back. Now next
Okay.
for the Companies Act and the Income Tax Act. So we'll go will rush through Stamp Duty Act. Otherwise, we'll go in depth and the remaining things I'll share to you. You can easily understand the MCQ and you can uh, complete it. I think coffee is also ready now. I'll
Yes,
come back
yes.
by
Yeah, ready, ready.
4:45.
Yeah.
You are not having coffee, na?
Sir, I just had, sir.
Uh-huh.
Thank you, sir. Have you done with your coffee, sir?
Actually, whether the session is a very dry session. See, explaining the act is very, very dry. I think, is it okay?
Yes, sir. It's fine, sir. It's fine, sir. Actually, instead of going through the act, explaining act with the
So you know
MCQs
the
is
act.
actually nice.
No, you know the act, no? You know everything, but you have to do it.
Yes, sir. As you mentioned, CMS and CS have got little low knowledge regarding this thing, sir.
See, to prepare a TP Act PPT, I spent more than 10 days. So I covered in almost 1 hour, 15 minutes. But it took me 10 days to prepare that PPT.
Oh,
And I'm
great work,
going
sir.
to be
Great work, sir.
competitor for Sharda also, because I'm just writing MCQ on Companies Act. So far, I've prepared some 782 MCQ so far I prepared.
It's a great work, sir.
And I have covered only up to that was that Articles of Association. Only up to Articles of Association I have covered 782 MCQs. There are so many questions in it.
Yes, sir. Yes, sir.
See, everyone has to do SWOT analysis. So my weakness is I've read the Companies Act only for the examination. In the year 1982, I cleared the examination of Companies Act in the year 1982.
Oh.
So this year, 18. So I've written in. I have not gone through that Companies Act of 2013. So to update me, just I started to prepare MCQ so that we can know the answers. We can prepare it. That will be useful to the examinations also.
Exactly. Exactly, sir.
Yeah, I think. Okay, we'll start this session. Let them join it. I think Govardhan sir, this is the experience you need. See, I put the instruments executed on behalf of or in favor of the government. See, in the previous years, I think recent charter accountants who have cleared the examination, they don't know that provision. There is one provision in the Income Tax Act called as Section 230A of the Income Tax Act. Section 230 of Income Tax Act, if you make any registration value exceeding 50,000 rupees, you have to get the income tax clearance certificate. Then only the registrar has got the power to register the document. Now, one customer, he approached me because I specialize in getting that income tax clearance certificate. And my luck with the income tax department or any department, if I concentrate on any one area, say Section 230A and everything, in another 2 years, they remove that section from the act itself. They concentrated. Then after 2 years, they removed it. Then I concentrated some other section. Say in salary, I used to get the income tax refund for the employees. And at that time, interest from house property has to be considered only by the income tax department or not by the employer. After that, they change the act, it can be considered by the employer. So there also I lost my profession. So that's why in my area, Salem people, they used to say that, Ravindran, we are getting, it is very, very tough session. You please concentrate on this section and do the practice. So that will be removed from the act. So this is my luck. So in this case, under 38, that client has approached me and so the person who is selling the property, he has to get the income tax clearance certificate. This is a thing. So So he has paid that buyer has paid. Normally, the buyer has to pay the stamp duty. The buyer has paid stamp duty of 13 lakhs around 13 lakhs stamp duty he has paid. Then I said, okay, you go and get the signature of the person who is selling the property. It's a temple property. It's a government property. Government has sold the property through auction. One private person has taken the property, and he has approached me for the income tax clearance certificate. When I hand over this section 230, there is form 34A to that person, that the property is being sold by the special officer of that temple. Then he said, sir, no, I am not. In that he has to give a affidavit saying that I am not having taxable income. He said, no, sir, the property is being sold by the endowment board. I am a representative of endowment board. So immediately it pricks my mind. Okay, it's an endowment board. Endowment board is nothing but government, state government. Because state government is the owner. State government is being controlled by governor of Tamil Nadu. So governor is being appointed by the President of India. So as per the Act, President of India or Governor of Tamil Nadu, they are not supposed to pay the stamp duty. So what I did, I find the application saying that, and I got a letter from Income Tax Department that no certificate is required for the government. So I have got a certificate from the Income Tax Department. Then along with this letter, I have written to registrar saying that you have to refund that 13 lakh stamp duty already paid, because the stamp duty has to be paid only by President of India. When President of India is being exempted from the Stamp Duty Act, you are not supposed to claim the stamp duty. You have to refund the stamp duty. Then he has forwarded the letter to the Chennai registrar office. That is what's that called? Just like GM registration. He has said, and everyone has agreed that no stamp duty is to be paid on that transaction. They have ordered the refund of 13 lakhs also. So this is the experience I have got in this case. That is instrument executed on behalf of or in favor of government. So government can buy, government can sell, no stamp duty is variable. This is the experience I have got. That's why I put temple case. This is with reference to point number 3. And point number 4, any instrument of sale or disposition of ships registered under Merchant Shipping Act, no stamp duty is paid. Any instrument executed or sold on behalf of the SEZ, then no stamp duty is to be paid. And as per section 8 of Indian Stamp Act, bonds, only 1% you have to pay, and no further stamp duty is to be paid. And no is payable on securities sold, depository, transfer between one depository to another depository, no stamp duty is paid. Negotiable warehouse receipts, there is no stamp duty. Assignment of receivables. See, in asset reconstruction company, bankers now they hand over the assets to the ARC. For that, no stamp duty is to be paid. Still, I think they are proposing a scheme to cover this point number 10. That is assignment of receivables. You have to pay the stamp. Normally, it is endorsement. Suppose if you are discounting a bill with the banker, there is no stamp duty. So this time, that means you are giving the power to the bank to collect the amount after the receipt of the money. So there is no stamp duty for this. And conversion of branch of a bank in a wholly subsidiary to holding company, no stamp duty is to be paid. Transfer of assignment of rights in favor of the financial assets and the SARFAESI to ARC. That's why I said ARC asset reconstruction company, if you transfer to collect the revenue, that is to collect the loan amount, that type of assignment does not attract the stamp duty. Okay, these are the important things, and other things I'll share because I'm moving to the Companies Act. Here, I'll highlight some of the important points in Stamp Act. See, one is single transaction. There is only one transaction. For that, you have to pay only one duty. But for copies, you have to pay the additional duty. Single transaction of sale, mortgage, or settlement. And any number of copies you can take. For any number of copies, you have to pay minimum fee of ₹1. And other things you have to pay more. Then stamp duty is only for one single transaction. This is one type of stamp duty levy on the document. And second thing is, one instrument contains several matters. Say in sale deed, various properties situated at various places must be linked by adding all properties. So this is another type of example I want to share. So one property is in Bangalore, one property is in say Mysore, and you can register both the documents in one sale deed, but you have to pay the stamp duty as per the property value in Bangalore for that property, as per the property value in Mysore. You have to pay the stamp duty, you have to add everything, and you have to pay the stamp duty. That is also possible. So this is another type of registration. I think I'm not, for sale deed, you have to pay only one stamp duty. Suppose you can do the registration in registration of two properties or three properties. Suppose even you can assume that one property in Calcutta, one property in Bangalore, one property in Tamil Nadu. You can register anywhere, but you have to pay the stamp duty for Tamil Nadu government rule, as per the Karnataka rule, as per the Calcutta state rule. You have to club everything and you have to pay the stamp duty in Tamil Nadu. If you register your property in Tamil Nadu, then this Tamil Nadu government will share the stamp duty to the respective state governments. So this is also possible. And normally in Kerala, now they have set this. In Kerala, in the Tamil Nadu property can be registered in Kerala, but you have to buy a property in Kerala, because in Tamil Nadu government, the stamp duty at that time it was 13%, but in Kerala it is only 3%. So what these people, they say, they will go and buy 10 square feet of land and they register this property there. But in Kerala, there was no, previously, this I am telling some 15 years back, they never charge extra amount. They charge the stamp duty according to that government's stamp duty. So this is the thing that happened in Kerala. Now they have plugged everything. So you have to pay. Suppose if it is in Tamil Nadu, you have to pay the Tamil Nadu stamp duty. Though you can register in Kerala, the Kerala government has to collect the stamp duty as per the Tamil Nadu government. They have to make the payment. This is another type of registration. Another thing is, one instrument contain one matter but comes under more than one description as per Schedule 1. Examples, partition deed. There are so many families, they are dividing the property, but in partition deed in Tamil Nadu, you have to pay the extra value, that is the top value of the property. This is as per the Tamil Nadu government rule, but I don't know about the other state, because the stamp duty levy on partition deed varies from state to state, and bonds and bill of exchange is the power of the central government. So in one instrument you can write anything, but you have to pay only one stamp duty. Then another point is, now this is another question, this you can, who has got the power to increase or reduce or waive the stamp duty? If it is central government has to increase, state government has to increase. The answer for the question is 35D. Stamp duty can be paid in the form of adhesive stamp, impress stamp, electronic mode, all the above. So what is this? Answer for this, all the above you can pay the stamp duty. Adhesive stamp, impress stamp, and electronic mode. What is adhesive stamp? What is impress stamp? What is electronic mode? Suppose electronic mode, you can pay to the registrar, you can transfer the money electronically. They will affix the seal. Adhesive stamp, normally it will be used only in banks loan documents. So you have to affix on the top. Then for that, adhesive stamps have been used. Impress stamp is, that is stamp paper. Everything is being printed. That is called as impress stamp. This is also one more question. Now you have executed a instrument outside India, and when you bring the instrument into India, within how many months it has to be stamped? The answer is 3 months, because you can execute any instrument outside India anytime, but when you bring the document into India, it must be stamped within a period of 3 months after it is received in India. How to confirm the receipt of that document in India? It may be courier, it may be the passport, it may be the visa, based on which you can fix the arrival of that instrument into India. That is, that too, it must be stamped within a period of 3 months from the date on which it is received in India. Then impress stamp, okay. Here I want to say one thing. You have purchased a document. For how many days that stamp paper is valid? You have purchased, say, 100 stamp paper. For how many days that stamp paper is valid? It is not typed, it is not written, it is not signed.
6 months.
180 days, this is Salini.
6 months.
6 months, Lakshmi. So for this, I request you to go through the Stamp Act, but I can simply or even brief everything. If no stamp paper is typed and written, you can use it for any years. Any number of years you can use it. There is no time limit to use the document. One. Now, my next question is, I want to surrender the document which I purchased. For within how many days I have to surrender? So after this, I'm going for company side. These are the basic questions I want to ask. Then after that, all questions you can, in MCQ you can read, you can understand. This is a basic question I want to ask you. I have typed a stamp paper. So okay, no, first I have not typed. I have got a blank stamp paper, say worth about 10,000 rupees. I want to surrender. I want my money back. Within how many months or how many what's the time limit to surrender my document, and what amount I will get? I think you can understand.
No
Can you
idea,
understand the
sir.
question? Can you understand the
Yeah.
question? There is nothing I have typed, but I have got stamp paper to the value of 10,000 rupees. Now I want to get back my money. So I want to buy a land. Suddenly that transaction has failed. Now I want to surrender that document to the government and get back my money. How
That
much?
stamp paper must have been issued in my name, na, sir?
Yeah.
Sir, it is not possible. I
But
don't think you
to
can
prove that,
return back the.
no, you have to prove that
See,
you are
you
the
can
owner of the
return, that I
document.
know.
You have to prove that you are the owner of the document. I cannot go and sell your document to the government and get back the money.
But sir, how can it is possible? Will the government give the
Is
money
there
stamp
no?
duty back?
No, it is possible. Actually, in land
It is
deals, it is possible. That I know it is possible.
Okay.
It is possible. I'll tell you one at a time. I'm giving the answer.
But I
When
think
you surrender the stamp paper to the person who was issued, that is a treasury of the
yeah.
respective district, they are issuing the stamp paper for sale. So you go and surrender before the treasury by writing a declaration and enclosing your KYC that I don't need that document, I want my money back, then there is no restriction. At any time you can go and surrender your document, then you can get money back by deducting 10%. You'll be getting 90% of the value of the document and not 100%. One. Second thing, now I have typed, I have given the document, I want my money back, but I have typed, I have signed, but I have not registered because transaction is cancelled. Now I want to get back my money back. What is the percentage? Same percentage. Because it is not registered, 90% of the stamp paper value I can get it back. But once if it is registered, I cannot cancel the stamp paper. So this is a basic thing which you must know because this will be useful to your practice. You can help your clients. So you can surrender before the treasury. You can get back your money of 90%.
Okay.
So after that, this I'll share to you. You can go through it. Another 15-20 MCQs are there. I'm going to stop now on the MCQ of Stamp Act. I'm going for Companies Act, which is a favorable area of Sharda and I think for Shalini.
Yeah.
You have to answer. No?
Can be said to be.
Huh?
Yes, sir.
Yes, sir. You are the king. I mean, sorry, queen of.
No, not like that. But yes, that's a core area.
Yeah, you can, and if I'm wrong, just advise me whether I am correct or wrong.
You are
So straight away,
embarrassing
I'm
us.
going for the MC. No, straight
You are
away,
embarrassing us.
Now this the fun zone starts.
saying, Purushottam sir, you are a cost accountant. Do you need your basic information? Then we will go for MCQ. Because Sharda and Shalini are very confident about Companies Act. You are a cost accountant. So, okay, I'll brief for some 10 minutes on the basic thing, then go for MCQ on Companies Act. Otherwise, we can directly go for,
You can go for MCQ, sir.
MCQ is direct, okay. This, Purushottam sir, this PPT will be useful to you, even
Thank
for
you.
the charter of, even for the companies. This is only a revision.
Thank you, sir. Thank you.
I am not here Companies Act. Just we are discussing it. So these things
Share by mail, I will.
is there in my PPT, sir. This you will get after the course. You will get in your WhatsApp group.
After the course.
Not after the course. Today's evening.
Yes, okay, sir. Right.
After the course means you have to wait for another 15 days. So this is the thing you have to know about the merger and amalgamation. So normally merger and amalgamation are same. All assets and liabilities have to be taken over by the new company. It is only a book value has to be transferred and not the revalue. And purchase consideration has to be given only in the form of equity shares. At least 90% of the shareholders continue, they are supposed to continue in the new company. Then same nature of business they have to carry. If any violation of any deviation from any one of the conditions of the above, it is to be treated as purchase of company and not as merger or amalgamation. These are basic 5 conditions they are to fulfill. Here, MCQ is ready from Companies Act. What are the kinds of share capital available? You can type it in the chat box. What are the kinds of share capital? Debenture and equity share capital, bonds and preference capital, debenture and bonds, equity capital and preference share capital. It is D. Share capital of the company include debentures, fixed deposits, stocks and furniture.
Stock.
Said C, Shalini said C. Stocks include, share capital includes stock. Shada ma'am, it is share capital, it is include stock, it is not debentures. Can equity capital be issued with differential voting right?
Yes, provided articles permit.
What's that?
Provided articles permit.
Yes, everything is article permitted. And everything should be, should be coming under table F.
Oh.
This act, otherwise it has to be covered by the Companies Act of 2013. Okay, here it is yes. With the differential voting right, you can issue the equity capital. Shares or debentures are movable property. This is a confusing question. You will confuse transferable movable property, transferable immovable property, movable property.
D, movable property.
So shares are equivalent to car, correct? Car is also movable property. The answer is B. That's why I said it's a transferable movable property. Shares with differential voting rights have to be issued. Shares with different voting rights should not exceed 26% of the total capital. The company should have distributable profit of 3 years. They are not defaulter under filing the financial statements and annual returns for the preceding 3 years and should be authorized by the Articles of Association. Shares with the differential voting rights, which one we have to eliminate, or which is the correct answer? And the answer is all the four are correct. Everything is required. I think Pushothaman sir said it's B. B means 2 and 3. No, so it should not exceed 26% of the total capital. So answer is D only. Can an equity share capital be converted as shares with a differential voting right? Can an equity share capital be converted? Existing equity share capital, it is not new. See, if you read can an equity capital, yes, it can be converted. Can an existing new equity capital be converted with differential voting right? With the differential voting right, only new shares are eligible and not the existing shares. So the answer for the question number 6 is no. Who has to sign the, it's a 1 mark question, the examination. Who has to sign the physical certificate to be issued under common seal? 2 directors or 1 director, 1 company secretary, if appointed as company secretary, general manager or ARB. Who has to sign the physical share certificate? Manasi, yeah, it is Shalini ma'am. It is D, 2 directors. In case of physical share certificate, it has to be signed by 2 directors or 1 director and company secretary. It is 7D. 2 depositories in India: NSDL, CDSL, RBI, central government. NSDL, RBI, CDSL, central government. The answer is A. can equity shareholders have a right to vote in resolution of the company? See, normally with reference to the Companies Act, I observe one thing. I think Sharda and Shalini, you can tell your views on this. When you file anything to the argument, should be within
Not every resolution, it's
and
there
when
is a course.
against the ROC order, we have to go for NCLT in 60 days, and NCLT they have to pass the order within 90 days. Is it correct?
It's not audible.
Anything to be filed to the ROC, it is 30 days. Correct? The ROC has to pass the order within 60 days on receipt of that notice. When you want to, after receipt of ROC order, you have to go for appeal to NCLT within 60 days. Then NCLT has to pass the order within 90 days. Is this statement correct? Company to ROC 30 days. Company to NCLT days. NCLT has to pass the order within 90 days from the receipt of the appeal. This is a common thing I noticed. Shalini madam, are you able to hear me?
सर प्रॉपर्ली नहीं सुनाई पड़ रहा.
Question number 9 is stopped, sir.
Huh?
Question number 9, can equity shareholder have a right to vote? The slide is not moved. Slide is not moved.
Yeah, I have not moved the slide now.
Number 9 only.
Now you are seeing now.
Sir is
Nine.
asking something different on the.
No, I have not moved the slide. Just I raised, I want to get a clarification from Sharda and Shalini. Anything to be filed in the ROC, it is 30 days. It's a common question. Common answer you will get. Based on ROC.
In most of the times.
In most of the cases. And from that, when you go for appeal to NCLT, it is 60 days from the ROC direction. And NCLT has to pass the order within 90 days from the receipt of the application. You
Yes,
just
sir.
observe and tell tomorrow, because I am also in the WhatsApp group. You can observe, you can tell your views on it, because it's my observation 30, 60, 90. So
I'll check it up, sir.
Huh?
I'll go through it more seriously because for NCLT, I'm not very sure, but other two things are correct. 30, 60, and 90, I'm not sure.
Okay. We will, okay, 30, 60, 60. Okay, Arun has given another thing, another confusion. Is it 30, 60, 45? Or 30, 45, 60? So this thing you have to be confident.
It's
Different shareholders have
30,
not
40.
paid dividend for 2 years. See, the question is, preference shareholders have got no right to participate at the equity shareholders meeting. If their dividends have not been paid for a period of 2 years, then they have got the right to participate in equity resolution passed at the equity shareholders meeting.
That's right.
So the answer for the question number 10 is yes. It is, they have got the right to participate at the every resolution passed by the company. A company issued its shares with discount, valid, voidable, void, or true. Can a company issue shares with a discount? Shada said D, that is true. A company cannot issue shares with a discount, but can issue shares at a premium. Only for sweat equity shares, they can issue. So the answer for the question is, it is void. A company cannot issue shares with a discount. Sweat equity shares have been issued to board of directors, shareholders, employees, government. Sweat equity shares. to whom we have to issue it is employees.
Sorry.
A company can issue shares with discount to central government, employees, Reserve Bank of India, IBBA. Equity shares can be issued with a discount to the employees and not to anyone else. So the answer for the question 13 is B. Sweat equity shares cannot be issued because sweat equity shares cannot be issued within 1 year since the date of commencement started, within 2 years, within 3 years, immediately on the date of commencement has started. So that means you can issue sweat equity shares within 1 year. So up to 1 year, you cannot issue sweat equity shares. You can issue sweat equity shares only after that. So 1 year is the correct answer, 14A. If authorized by articles of association, can a company other than the infrastructure company issue redeemable preference shares? It is authorized. So other than infrastructure company, a company can issue redeemable preference shares for a maximum period of 20 years, 30 years, 45 years, 22 years. It can be issued for a period of 20 years in the case of companies other than infrastructure companies. For infrastructure company, you can issue shares up to a period of 30 years, maximum of 30 years, but repayment starts from the 21st year in case of infrastructure company. That is remaining 10 years on pro rata basis, every year 1/10 has to be redeemed. This is with reference to the redeemable preference shares. So the answer for the question 15 is A. For infrastructure, it is 30 years. Preference shares should be redeemed out of equity capital, profits, loans, director funds. You have to redeem the preference shares out of the profits and not out of the loans. So 17B. Bonus shares shall not be issued in lieu of dividend, loans, fixed assets, preference capital. It's a normal thing. Bonus shares shall not be issued in lieu of dividend. For dividend, you cannot issue bonus shares. So answer for the question 18 is A. Once again, I'm telling, I'm just giving the revision. I'm not here to take the class. I'm not teaching you any Companies Act. It's only a revision. Just we are doing it. What is the, this is a very important thing. What is the gap between one buyback and another buyback? So buyback is allowed. What is the gap between one buyback and another buyback?
1 year.
3 years, 2 years, 4 years, 1 year. Vijayalakshmi said 1 year. Shalini said D. Yes, it is 1 year. D. Is it my closing time now? Music? Okay, different types of debentures. Security, secured, unsecured, on the basis of convertibility into shares, on the basis of redeemability or redeemable. The answer for 20th is D. D is the correct answer. No company shall issue a prospectus or make an offer to the public or to the members. 500 for the subscription, 550, 675, 600. It is 500. Amalgamation includes absorption, merger, holding company, and subsidiary company. Amalgamation includes merger, holding company, subsidiary company. It is I think is it who is getting the phone? Huh?
I'm sorry, I think my daughter is practicing violin. I'll just close the door and come.
Oh, one second, one second.
Okay.
Oh, no. Oh, when they are playing violin, I think I remember. Okay, okay, sir. Thank you, Godan, sir.
Yeah, thank you.
See, based on my, I think speech need that type of violin background. Okay, next thing is amalgamation includes is merger. It is not absorption. It includes merger. The answer is wrong. Two types of amalgamations are: one is merger, one is purchase, and holding and subsidiary company. The answer for this question is 2D. Dash percentage of shareholders of transfer company becomes shareholder of the transfer company in the case of amalgamation. How many? I mean, what's the percentage? See, that is 90, yeah. It is, see, 90% of the shareholders of the transfer company must become shareholder of the transferee company in the case of amalgamation. Yes, correct. Who has to approve the compromise or arrangement between a company and its member? RBI, central government, tribunal, or SEBI? It is central government, See, where to file the compromise or arrangement? You have to file everything to the tribunal and not to anyone. So the compromise or arrangement has to be approved by the tribunal. So it is C. Here, application to tribunal has to be submitted by whom? Members, company, creditor, liquidator in the case of voluntary liquidation. That is with reference to compromise, arrangements, and amalgamation. Those applications have to be submitted to the tribunal by whom? A, B, C, or all the above. So everyone has got the right to go for the compromise. So the answer for the question is 4 or all the above. All the above from A to D. Which one is false? See, in sectoral regulations, it is everything is related to the central government and central government allied activities. In sectoral regulator definition, state government is excluded. So which one is false? Central government, income tax authorities, all are sectoral regulators, RBI, SEBI, registrar, respective stock exchanges, official liquidator, competition, and D is the wrong answer. So state government is not included in the definition of sectoral regulators. Sectoral regulators have to send their representation within 30 days. They have to say, because they have to send this to their representation within 30 days. If they are not sent their any representation with reference to the compromise promotion, then it is deemed to be accepted. So tribunal may dispense with the meeting, because now the persons, they have all the creditors, they applied to the tribunal for the compromise. But if the percentage of 60%, 90% or 70% or 80%, if they gave their acceptance, then there is no need for the tribunal to pass the order of compromise arrangement. What is the number of percentage? It is 90% of the class of the 90% of the creditors, class of creditors have to give the acceptance. file the order of the tribunal with ROC. This is a question I raised. File the order of the tribunal with ROC by the company. 45 days, 30 days, 75 days, 90 days. Anything to be filed with ROC, it is 30 days. Now, buyback of securities are allowed under compromise or arrangements. True, false, partly true, partly false. Whether buyback of securities is allowed under compromise or arrangement, it is said to be no. No buyback securities are allowed in the compromise proposal or arrangement proposal. So the answer for the question 10 is false. Then what is the appointed date? Date mentioned in the order, date of service of the order, date of post, date of reply. What is the appointed date? The appointed date is the date mentioned in the order is the correct answer. So the answer for the question 11 is A. Minority shareholders' deposit amount has to be maintained in a separate bank account for a maximum period of dash year, and the repayment has to be made within dash days of claim. See, under compromise arrangement, the minority shareholders, they have to be paid. So the company has to maintain the account for a period of 1 year, and on the date of claim, within the date of claim, within 60 days, they have to make the claim. They have to make the payment. So the answer for the question 12 is B. So they have to maintain a separate account to be paid to the minority shareholders for a period of 1 year. And if on the date of claim, they have to repay the amount within 60 days. Effective date of scheme of amalgamation on merger. It is date of tribunal order, date of receipt by ROC, appointed date, date of RBI intimation. It is the appointed date, because the date of tribunal order is appointed date. Appointed date is also the date of tribunal order, but it is in the tribunal order they will say that this order comes into effect from this date. So that date is to be called as appointed date. Minority shareholders have to compulsorily transfer to the majority shareholders at a predetermined price. Not compulsory, optional, compulsory, not optional. You can tell. Minority shareholders have to compulsorily transfer to the majority shareholders at a predetermined price. It is optional by Vijayalakshmi. Arun sir said optional. It is not compulsory. It is optional. If they want to sell, they can sell, otherwise not. Now we are going to winding up. As per Companies Act of 2013, winding up means winding up as per Companies Act of 2013, 16 IBC, and 2016 winding up as per the Income Tax Act or A and B. So winding up is possible as per the Companies Act as well as by the IBC code, Insolvency and Bankruptcy Code. So the answer for the question is D. Now, power of winding up lies with tribunal, RBI, ROC and state government. Here, a company has to make application for winding up to the tribunal, NCLT. Then tribunal has got the power to issue winding up order. So the power goes to tribunal. So the answer for the question number 2 is A. Reasons for wound up of the company. Company make the petition to tribunal under wound up by a special resolution. Then on just and equitable ground, These are the reasons. The answer is F. Okay. And just on equitable ground, you can go for the wound up. Default in filing the financial statement on application by the registrar or by anyone authorized by the central government. And if the company acts against the national interest, then the company can be wound up. The reason for the wounding up is 3F. The following persons are eligible to present application for winding up: company or any contributory, registrar or any person authorized by central government in case of falling under section 271B by central government or state government on a fraudulent manner. The answer for the question 4 is D. Copy of the petition has to be filed before registrar, and the registrar shall submit his views within dash days on receipt of the petition. It is 60 days. Registrar has to give within 60 days. Power of the tribunal: dismiss the order with or without cost, appoint a provisional liquidator till the company, till the making of the winding up order, making an order for the winding up of the company with or without cost, all the above. So this is the power given under section 272 to the tribunal. So all the above is the answer. Tribunal has to pass the order under section 272 within a period of 60 days, 90 days, 45 days, 55 days. I think Arun sir is now confident. It is not 60 days, it is 90 days. Huh? It is 90 days. That's why I said 30, 60, 90. I think tomorrow Shalini ma'am and Shada ma'am, they have to give the areas where more than 30 days are required. I will not leave you because you are going to be there in the group. Nah? Tomorrow, definitely I will ask the same question in the WhatsApp group. An asset is mortgaged or there are no assets. Can a tribunal refuse the winding up proceedings? Because the company has already mortgaged its property to the bank and the company has got no asset. Can a tribunal refuse the winding up proceedings? No, that is, all assets are mortgaged. You cannot go for winding up. Whether the answer is partly yes, partly no, or yes or no. Arun sir said B, that is a no. Vijayalakshmi ma'am said yes. So that means company can refuse, tribunal can refuse. No, the court cannot refuse the winding up proceedings, even though the properties are being mortgaged or there are no assets. So they have to proceed against the winding up. Provisional liquidator or company liquidator can be appointed by the tribunal from the list of RBI, insolvency professional from IBI, ICI list, and district collector. Okay, now I'll pose a question in other manner. There is no IBBI. The answer is correct. B is the correct answer. Now, IBBI is not there. Then from whose list this provisional liquidator or company liquidator can be appointed? As per the court wish, anyone can be appointed. But in every district, there is a list called liquidator list. All district collectors. Suppose if you want to expand your practice, you go to the district collectorate, apply to the district collector, sir, I want to become the liquidator of this district. There is a panel. You just apply, you will get the panelist. Because this winding up proceedings is for the companies. But what about the individuals and firms? For HUF, for other than the company, you can be appointed as a liquidator based on the official list given by the district collector to the court. From there, you will be picked. So there is a panel in every district collectorate so that you can become a liquidator. It's a professional opportunity area. Please do it. You will definitely get. Anyone can be, even Purushothaman sir, even though you are a cost accountant, you can also apply at Mysore. You go to the district collectorate, and also another information I want to share, in every district, this is the opportunity available to the chartered accountants and not to the company secretary and not to the cost accountant. Any chartered accountant can go to the district collectorate. There are more than 2,000 societies in the collectorate to get the accounts audited. So you just imagine the minimum fees will be around 5,000 rupees they will pay you. So 5,000 into 2,000. That is your, suppose if you get entire audit, you'll be getting that fee. Suppose if you are getting 100 audit out of that 2,005, you'll be getting 5 lakhs. So it's a professional opportunity area. You go to the district collectorate, get the, because there are a lot of societies to be audited by the chartered accountant. In my area, I tried. They gave me only one file on a just check basis. They gave me only one file. Then I commented against the sub collector who was the chairman of that society. He has withdrawn the money on self basis. He has withdrawn. I said he has withdrawn the money. He has purchased the goods. I said any payment has to be made through account payee. District, sub collector has got no power to withdraw the money, and I have given the comment that has been endorsed by the audit committee, AG party. Now that sub collector is under suspension. So next year they have not given me the audit. So when you report it, you have to also face these consequences. And another case in the same time, there is one society in every district, not only in Tamil Nadu, in entire district of all states, district blindness control society is there. You just take note of it. If you are a chartered accountant, you take note of it. There is one thing called district blindness control society. All district collectorate, they have got that account. So then the collector is the chairman of that society. So they have given me the audit. I did the audit. And collector, as a chairman of that society, what he did, he has transferred the fund from Salem to Madurai without permission. I said, though collector is the comment which I passed, though collector is the chairman of the society, he has got no power to transfer the fund from Salem to Madurai. It has to be recalled. Otherwise, the amount of 30 lakhs which he has transferred has to be recovered from the salary of the collector. This is a comment I passed. Next year I have been removed from that. They call the money, they recall the money because the AG party has approved it. But they are not allowing me to do the audit. Because when you pass any comment against anyone, okay, they will pay the fees. Next year you will not be getting the audit. In one of the scheduled banks, where I have reported a fraud of 100 crores. So this I want to share here. It's a accident claim checks. It is being looted by, I use the word looted by the panel advocate as well as by the branch manager to the tune of 100 crores. They colluded and they have encashed other parties' checks. When I reported, the branch manager has gone on VRS. The general manager has also gone on VRS. The panel advocate, he has surrendered his valuation, he surrendered his advocate position, and everyone has gone on VRS. They are not able to recover that 100 crores. The punishment is next year I have not been given the audit. Because that's I mentioned only the bank, I have not mentioned the bank name. Because as per the professional ethics code of conduct, declaration of fidelity and secrecy is there. You are not supposed to leak out the bank's name. I have already written to President of India to share this, but I have not received any reply. Because if I receive reply, then when I report this, definitely I know that the government will be shut. Government will be in trouble. I have not received any reply so far. Okay. The thing is, you can give the report, but you will not be getting the audit in the next year. This is my experience. And cooperative audit can be conducted by cost accountant in Karnataka. Yes, sir. You are from Mysore. And nowadays, in Tamil Nadu also, they are considering this provision. See, in Tamil Nadu, what they are doing, see, we are filing income tax returns for the cooperative societies. See, cooperative societies, at their homes and at their whims and fancies, they are giving the audit to various chartered accountants. Now, some 10 chartered accountants, they have formed a cooperative society only for the purpose of audit. They said that we are the members of the society. You have to allot the audit only to this cooperative society and not to anyone else. In this manner, they canvass the society, all the societies. So the minimum fees will be around 10,000. Minimum fees is 10,000. So there are more than 70,000 cooperative societies are there in Tamil Nadu, in particular some 4 states, 4 districts or 5. So 70,000 into 10,000, you imagine the fees that is going to that society. See, what we are chartered on, we are getting, we don't want to lose our field. So even I personally said, it is against the code of ethics. See, because a chartered accountant cannot be he can be a member if it is, what's that, for non-profit making organization, you can be a member. For profit making organization, you cannot be a member. So you cannot be a director, you cannot be a member in cooperative society. So the society itself is wrong and he is a member. So why you are not taking disciplinary action? This is the thing I have reported to the ethics. Now discussions are going on. So we have to save our skin. We should not deviate because they have got very good influence in state government. They are getting the audits. So these are the things you have to be very, very careful. The thing is, not only chartered accountant, for company secretary or for cost accountant, the identification of area is very, very important. Suppose if you identify one area, then all people, they will come. They not only spoil you, they spoil the entire procedures. So this is the thing, this is happening in our profession. 9B is the correct answer. Now insolvency professional, they have to get the professional liquidator list and the company liquidator list. Liquidator has to submit his accounts to a tribunal twice in a year, once in a year, 3 times in a year, never. Because liquidator, they have to submit the accounts because tribunal is the appointing authority. Twice, that is Shalini ma'am said twice. Arun said B once in a year. It is twice in a year you have to submit the report to the tribunal. So that's why I said if you crossed 10 years of practice, please be qualified in insolvency professional. See, I have qualified IP as well as I have qualified RB. There is register valuation. I have never applied for the panel to IBBA because I want to practice for individuals and firm. Still, the government has to introduce. I want to practice only for those areas. But the IPs, because we have got a lot of IPs friends, they are sending the valuation files to us. So they are taking all risks, but they are sending the valuation work to us, to the register valuers. You have got a very big professional opportunity in valuation. So try to complete it at early, but you should be a master in all valuation methods. But next to my suggestion is you have to do some groundwork. From base work, you have to do it. You will not directly get any file there because there will not be any panel other than the NCLT. I have suggested to the IBBI that just like insolvency professional, why you have not created panel for the register valuers? There are register valuers for machinery, equipments, and SFA, securities and financial assets. You have to create a separate. This idea I have already mooted. I already proposed to IBBI. You must create the panel of valuers. Just like IP, you have to create the panel of valuers. From there only IPs, they have to pick the values so that all valuers will get equal work. Otherwise, you allot the valuation work to the valuers. IBBI, they have to allot the works to the valuers so that the work can be done easily. So this is the area where I think slowly we will get into the panel. So try to complete at the earliest. Who has to conduct the audit of accounts of the liquidator? So So liquidator accounts are also to be audited. Who is the appointing authority? Who is the appointing authority for the liquidator? It's a tribunal. So tribunal has to conduct the audit of the tribunal. Accounts of the liquidator, but tribunal can appoint anyone to conduct the audit, but the audit has to be done by the tribunal, either by charter accountant or by any officials. They can do it. Can a voluntary winding up is applicable under Companies Act of 2013? Due to IBC 2016, it is withdrawn. Yes, it is possible. As per tribunal order, this is possible. RBI can order for this winding up. The question is, can a voluntary winding up is applicable under Companies Act of 2013? After the introduction of IBC of 2016, the voluntary winding up is being done only under IBC and not under Companies Act of 2013. Before IBC introduction, then it is possible under Companies Act, but after introduction of IBC 2016, it is not possible. The winding up proceedings have been withdrawn as per the has been drawn from the Companies Act of 2013. Official liquidators are appointed by state government, tribunal, central government, IBBA. Who has to appoint the official liquidator? All official liquidators have to be appointed by the central government. State government has got no right to appoint official liquidator. Tribunal has to appoint that company liquidator that can be appointed. It can appoint, but official liquidator has to be appointed by the central government, and they are the employees of the central government. Their services, their salaries will be paid only by the central government. Any number of official liquidators can be appointed. Official liquidators are employees of state government, tribunal, central government, and IBBA. We already discussed. They are the employees of the central government. Remuneration of official liquidator are being paid by. They are the employees of central government. Who has to pay the salary? It's only a central government. Government dues have to be paid as per section 327 after workman wages, holiday remuneration, priority. Hence, the question is wrong. No need to make the payment. Government dues, as per section 327, government dues comes first. As per the Companies Act. In IBC, it comes under the fourth place. So here it is a priority. The question itself is wrong. The answer is C. Priority, hence the question is wrong because the government dues have to be fixed. So here I want to make one question. There is an arrears of income tax to the tune of say 1 crore. Properties are there, but those properties have been mortgaged to the bank. Can the central government claim that it has got a priority over the tax, priority over the loan? Here, bank has given say 2 crores to the against that property, but income tax arrears are to the tune of 1 crore. Who has got the preference? Whether it is a central government or income tax department or the bank?
First charge is by the bank, so
Who's
bank
on
will
this?
get the priority.
Huh?
First charge is with the bank, so bank will get the priority.
Okay, then. But government is the supreme authority.
But sir, as per the instrument, if it is mentioned, whether where is the first charge, who belongs to the first charge, is the bank or the government? It's obviously the bank,
Okay,
because bank
I'll put the
always goes
question,
for the.
sir. I'll put the question in a different manner. I have given 2 crores as individual to that party. Income tax arrears are to the tune of 1 crore. Whether income tax department can put into the first charge. You said it's a first charge. So I have got the first charge. Income tax department comes as the second charge. Which charge it has to be claimed? See, Supreme Court said, it is, if it is the bank has got the first charge. For others, government has got the first charge. So this thing you have to bear in mind. Another thing is a company. You know that company is limited by shares. Suppose in case of loss, the liability is limited to the extent of share capital. This is a normal thing with reference to Companies Act. In case that's a huge loss, can a director's personal property be attached to this loss? There are directors. Companies have incurred a loss of 20 crores. The director's total, that is, the shareholders' investment will be around, say, 10 crores. Can a director's personal property be attached?
Whether they have given guarantee to it?
Whether they are giving guarantee or not,
Sir, if the guarantee is given,
automatically ruled out. Guarantee
but
means
still,
automatically ruled out. Everything is being attached. In the case of winding up, they are not able to recover the loss. Supreme Court said, yes, you can attach director's personal property.
Sir, to the extent of unpaid shares or the full value?
So unpaid shares, yes, I said director's personal property. It is not unpaid shares or paid shares, called capital, recalled capital. I don't know anything. So my
no,
question is,
he's asking to the value of what?
Shada ma'am and Shalini ma'am, I think you can also take the lead in the WhatsApp group. One thing I already said about 30, 60, 90. And second thing is, can a director's personal property be attached in the case of winding up to make the to cover the loss? This also you can do the working. So Purushothaman sir, you said some Surface Act. What is Surface Act?
Surface Act is basically
No, I know Surface Act, but Purushothaman sir in chat box he has put Surface. Okay, this is with reference to Companies Act. I think just completed the Companies Act. See, this is a photo I have taken from Jaipur Museum. Went to Jaipur and taken this photo. But this is going to be, I used this photo regularly for the concurrent audit. See, in concurrent audit, I started my presentation with Taj. I used to say, first slide is Taj Mahal. Because I went to Taj, I have taken photo. And I used to ask them, what is Taj? Then they said that, yeah, it's beautiful and everything. Then after that, I said, concurrent audit is just like a Taj Mahal. When you look from the distance, it is very beautiful. But now you can't hold of the audit. You catch the audit, now you hold the audit. But when you enter the audit, it contains a lot of swords. You should know the technique of handling all swords. If you are not able to handle the swords, it will cut you. Just like that, a concurrent audit. So in that manner, I used to start my introduction. I think photo is GKR. No? What photo? This is mine, sir. It's not GKR photo. This is Ravindran photo. It has taken. Even I put the glass, just like it will come. But some 2 years back, I have taken this photo. Really, you failed. Purushottam sir, you never post me MGR. Na? Okay, this is the thing I want to share uh, with reference to Companies Act. Now I am moving to the Income Tax Act. I think this will be useful. I think to charter accountants, they knew it, but company secretaries, they would have written some paper on Income Tax Act, then they will not be a master there because they are master in all Companies Act. But I am going to cover Income Tax Act also. I think someone is not comfortable. Okay, so MCQ from examination angle. I am not here, once again telling, I am not here to teach Income Tax Act, just we are doing the revision. So I am covering almost all charter accountants. I think they are able to answer. I think Sharda and Shalini, they will be slow in giving the answer because it is related to income tax. If it is Companies Act, you will be a master. Okay, and general. Income tax is a levy on. Don't worry, I'm going to share this PPT to you, and it will be useful to Purushottam sir and all company secretaries. It will be useful. Income tax is a levy on. It's a levy on direct tax. Okay. Next slide is Constitution. This I'm going to start. Which is correct. Income Tax Act governs levy of income tax in India. Rules is being formulated by CBDT, that is Central Board of Direct Taxes, for proper administration. Circulars are issued by CBDT to clarify the meaning and scope of certain provisions in that. Notifications are issued by CBDT to give effect to the provisions of the Act. Among rules, everything is correct. The answer is all are true. A to D, all are true. It's only theoretical portion I have given here. What's that? AOA? Na? Shalini ma'am, you said AOA. What is AOA?
All of above. All of above.
Huh?
All of above, sir. All of above. That means all are true.
All of the above. I said articles of association. Okay. It's not there when you put AOA. I said it is AOA, articles of association. Income tax is a tax levied on total income of the previous year of every person, net income of previous year, gross receipts of every person, or cash income of every person. Vijayalakshmi said A. Shalini said A. So total income of the previous year or net income of the previous year? So the answer for the question is A. It is total income of the previous year. What is previous year? Previous year is, I think, immediately preceding the previous year, financial year immediately preceding the assessment year immediately preceding the financial year, previous year is previous year. What's it? Said B. Okay, previous year is the financial year immediately preceding the assessment year. But what about question number, 5D? Previous year is previous year. So the answer is B only. Assessed in the same year. This is a important thing. This will be useful to the practice also. For shipping business of non-residents, persons living in India, AOPs, body of everything, they have assessed in the same year. None of the C is the wrong answer. The answer for the question 6 is A and B. It is to be assessed in the same year. So answer for the question is B. Manasi, I think I chartered accountant, and Vijayalakshmi madam is also keeping quiet. Manasi madam, are you chartered
Yes,
accountant?
sir. Yes, sir.
I think Vijayalakshmi madam is also keeping quiet now.
Yes, sir. There was some disturbance. Yes, sir.
Yeah. Oh, I am disturbing you now.
Sir?
You said some disturbance. Is it from Ravindran or?
No, the voice, there was a little bit of a disturbance.
No, you said some disturbance. Okay.
Clarity issue.
Right, okay. So this I'll skip because it's all later. This you can because it varies from every assessment year. So I'm going to skip this thing. What's the firm's income tax? Means individual has got one rate, partnership firm has got the other rate. So what's the tax rate? It is 30. This is another thing. The following persons are taxable persons as per the Income Tax Act of 1961. Resident, not ordinary resident, non-resident. There is no such person under the Income Tax Act. Is it correct? That is wrong answer. Only 1 and 3 are correct. That is resident and non-resident, they have to pay Income Tax Act. That is also wrong. Resident, not only resident, and non-resident, they have to pay Income Tax Act. That is also wrong. So the answer for the 17th question is D. All 1, 2, 3 are correct. That is all the resident, non-resident, and not only resident, they have to pay the Income Tax Act. This is with reference to status determination. Stay in India, that is residential status is being decided if he stays in India for 182 days or more, stays in India for immediately 4 preceding year for 365 days or more, and 60 days more in the relevant financial year is called as C, is called as resident. If he has stayed for less than 180 days, he will be called as non-resident. The following incomes are fully exempt from income tax. Share income of a partner, member of HEO, educational scholarship, everything is exempted from income tax. So the answer for the question number 25 is true. See, I have skipped some slides because on going through it, you can easily follow because it related to the slabs. What if is it 5% or 10%? You can easily follow points and income tax rate.
हमें कुछ बोलना नहीं है हैं
हाँ?
कुछ भी नहीं हेलो
Agricultural income has to be added to the total income if income exceeds the basic limit to arrive at the tax calculation purpose. Agricultural income is exempt from income tax act, but for rate purpose, they have to include the agricultural income if it exceeds the basic limit. The answer for the question number 26 is true. And with reference to salaries, the standard deduction applicable for the financial year 1920. So it is, you just wait for the financial year 1920. Is it correct? The answer is correct. It is 50,000 rupees is applicable for the financial year 1920. You just wait when you read the question. You just see whether it is assessment year or financial year. It is financial year, so answer is correct, 50,000 rupees. Salaries under 17.1 does not include. This is a repeated question in the examination. It does not, salary includes gratuity, wages and bonus. Interest is not included in the salary. So the answer for the question is interest. This is a regular question being asked in the examination. So salary does not include interest. When A owns a house and resides in that house, can he claim HRA? The question is, A is the owner of the house and he is entitled to, can he entitled to claim HRA? No, he cannot entitled to get HRA. Suppose, okay, that is covered in the next question. So the answer is B. Interest-free or concessional loan is given to the employees by the employer to the tune of 1 lakh. Whether the interest has to be treated as perquisite, interest rate charge is as per RBI Act. That means he has given interest-free or concessional loan to his employee. So in salaries, employer-employee relationship is a must one. Here, interest-free loan is being given to the employee to the tune of 1 lakh. Whether it can be exempted or not, as the amount exceeds 20,000, it has to be charged to income tax. So answer for this, up to 20,000 is allowed. Beyond that, it has to be treated as income. Beyond that, it has to be treated as perquisite. Gratuity received by the central government employee is 25 lakhs. At the time of retirement, he has received a gratuity to the tune of 25 lakhs. Is it taxable? No, fully taxable. Exempted only up to 10 lakhs. It is fully exempted. The gratuity is received by the central government employee. So you have to be very, very careful. If it is a state government employee, you are correct. If it is central government employee, it is fully exempted. So that's why I said when writing the examination, you have to be careful whether it is a state government employee or central government employee. So here I put the answer 31A. Employer gives 20,000 to his employee. Is it perquisite or not? Yes, the gift exceeds 55,000 rupees. This is a perquisite. Payment covered under Payment of Gratuity Act. The least amount of the exemption is 20 lakhs or actuals. Up to gratuity is being covered up to 20 lakhs or least amount. The statement is correct because it's an amount to the Gratuity Act, Payment of Gratuity Act. You are doing payment under Payment of Gratuity Act, then 20 lakhs. Now, the payment which are not covered under Payment of Gratuity Act, the least amount of exemption is 10 lakhs or actuals. Yes, it is correct. Say simple, central government gratuity 100% exempt. If the payment has been covered by Payment of Gratuity Act, it is 20 lakhs or actuals, whichever is less. If it is not covered by Payment of Gratuity Act, the least amount is 10 lakhs or the actuals, whichever is less. Leave encashment at the time of retirement is exempt. It's a basic thing you should, I think everyone will know it. Leave encashment at the time of retirement is exempt. An employee has encashed his leave to the tune of 25,000 during his employment. He is claiming exemption of 25,000. He is correct. He can claim only up to 10,000. Encashment of leave at the time of retirement is exempt. Hence, it is fully taxable. Here, the word is during employment, he has received encashment of it. So, during encashment and during employment, if he has received any leave encashment, it is taxable. So, the answer for the question is 34C. How to arrive at the net annual value? Gross rent minus municipal tax, gross rent plus municipal tax, gross rent minus repair cost, gross rent plus repair cost. Net annual value is equal to gross rent minus municipal tax is the net annual value. This is a very, very interesting question. This will be useful to your practice, even to your personal life. Say your land is owned by wife. She is not an employee. The housing loan they have availed from the bank. income of the husband is being considered, can the husband claim interest paid on housing loan against his income? Housing loan is borrowed jointly by the husband and wife. Husband is an employee of land is owned by wife. Can the husband claim interest paid on housing loan against his income? This will be useful to you. He is the co-borrower, husband can claim. Then, no, the property belongs to wife. Husband cannot claim the interest. Interest can be shared because as a co-borrower, they have received, they can share it. What is your opinion on this? It's a practical question I'm asking. It's already a lot of decided cases against this point. Who is the owner of the property? Land belongs to wife. So only the owner of the property, they can claim interest under section 24(1) as well as the principal repayment under section 80C. Here, husband is only a co-borrower. He is not the owner. His income is considered for the repayment purpose. Only the owner of the property can claim the interest paid against the loan. The husband is making the payment, okay, it's only a payment, but the deduction is allowed only to the owner of the property and not to anyone. So the question number 37, the answer for this is 37B. See, this is a practical question which I faced in my area. In my area, I have filed returns, but I have claimed the deduction. But the assessing officer, they say that only the owner has got the right to claim. Then it went to the court. Then court decided that it cannot be claimed by the husband. It can be claimed only by the owner. There's a separate notification is also there in the income tax department, but that has been issued some 12, 13 years back. They have issued a notification. It's already a decided case. But if the husband enters into lease with the wife, I think for a period of 11 years or 12 years, then he can be treated as deemed owner. Suppose if you are doing practice, you can advise your client to enter into a lease agreement with your wife so that for a period of 11 years, I think for 12 years, then that husband will be treated as deemed owner. Then he can claim deduction under section 24(1). So this is a planning area. You can do it. Here, for this direct question, it is 37B.
Sir, can I ask one thing related to the last question? Sir, in this case, the property belongs to the wife. But suppose there is a flat which has been taken on housing loan by the bank, and both the husband and wife are the co-borrower, and the bank has issued the agreement in the name of both the husband and wife, and they both are paying back the interest to the bank jointly through their accounts. So in that case, sir, who can claim the interest, or none of them can claim the interest?
The interest has to be claimed by the owner of the property. That's all. Who is the owner? He is only a co-borrower. He is not a co-owner. He is only a co-borrower. Co-owner means the property should be in the joint name. If it is in the joint name, then you can bifurcate the interest.
Yes, that's
50%. If he is a co-borrower, he is made as a person to repay the loan, but he is not the original owner.
Mm-hmm.
So deduction under section 24(1) is entitled to be claimed only by the owner of the property and not by anyone else.
Okay, and if the owner of the property are both the husband and wife, that means both of them can claim.
For that, that's why I'm suggesting the husband should enter into a lease agreement with his wife for a period of 11, I think it's 12 years, I think. For 12 years you enter, then the husband will become deemed owner, then he can claim deduction under section 24(1). Here, where the property is self-occupied for his own residence, or unoccupied throughout the previous year, owing to his employment, business, or profession carried out in either place and residing at other place in a building not belonging to him, its annual value will be dashed, provided no other benefit is derived from such property. He is a owner, self-occupied. He has not occupied the house. He resides somewhere, but now it has not been let out on to someone. So the net annual value towards that property is nil. Now it is previously it was one house. Now it is two house. Now the assessee has got two house property. Exemption for both houses towards NAV can be claimed. Yes, he can claim for the both house as per the present norms. But previously it is available only for the one house. Now this last year they have amended. It is for the 2 years. For the two houses. For the two houses they can claim exemption. Mr. A holds a property as stock. Stock means he is a seller. He is an apartment promoter. He is holding some 7 houses in that apartment. He is entitled to claim NAV for how many years? Till the certificate of completion of the house is obtained. Only if you are the owner, if you have got only one house for your residential purpose, you can claim. But you are retaining it as the house property. It's an apartment concession. You are not sold it. You are just retaining. You are having that property as stock. For how many years you can claim NAV? It is for C. For up to 1 year, you can claim as NAV. After that, it is not eligible. It has to be taxed as, suppose you have constructed the house, but you are not able to sell it. So deemed rental income will be added to your income. So after 1 year, you can claim the benefit of NAV. NAV means net annual value. That is treating the net annual value as 0. That is, if it has crossed 1 year, then deemed rent will be applicable. Rules of deemed rent will be applicable. Standard deduction towards repairs can be claimed by the assessee to the extent of repairs deduction. It is 30%. C. Yes. Mr. A has let out his property. He has paid 3 lakhs as interest towards housing loan. What is the eligibility to adjust towards NAV? He has let out, so rent minus municipal tax, that is there, that is comes at, that is to be said as NAV. It is a let out property. What is the interest to be adjusted?
3 lakhs can be adjusted. Well, 3 lakhs can be adjusted. Only the housing loss is restricted to 2 lakhs.
If you have let out your property, 100% accrued interest. It is not paid interest. With reference to housing loan, with reference to housing thing, it is accrued interest and not the paid interest. Up to any amount, even if they have paid interest of 4 lakhs, you can. So that's why even in my filing of the income tax return, I used to say that though the house is being self-occupied and if the interest paid more than 2 lakhs, say if they paid 4 lakhs interest, that is accrued interest is 4 lakhs. I used to say that the house is being let out for 5,000 rupees. So 60,000 rupees rental minus municipal tax. So NAV minus this interest I used to claim. So 42C. See, Mr. Ravi has borrowed a housing loan and that also is being self-occupied. He has paid interest to the tune of 3,50,000. To what extent Ravi can claim interest under section 24(1), it is 2 lakhs. Because if it is a self-occupied property, NAV is 0. So minus 2 lakhs. So you can, if it is a let out property, then you can claim up to any interest, any accrued interest to any amount you can claim. Mr. Kumar is not the, sorry, I said it is 11 or 12 years, it is 13 years. Mr. Kumar is not the owner of the property, but he has got lease agreement for a period of 13 years. Can he be called as owner of the property? No, he is not entitled to any right. Yes, Mr. Kumar can claim deemed ownership as the lease agreement exceeds 12 years. So a lease agreement, if it exceeds 12 years, then you can be called
C.
as deemed owner.
C.
So
Deemed owner.
here, if the owned by wife, the husband can enter into a lease agreement with his wife for a period exceeding 12 years, then that husband will be called as deemed owner. He can claim deduction under section 24(1). So tax planning part I am telling. Here, the answer for the question is yes, it can be called as deemed owner for that property. This and skip. Income chargeable under the head business under or income from other sources has to be computed in accordance with either cash basis or mercantile basis of accounting regularly employed by the SSE. Whether hybrid system is applicable. In India, hybrid system is not applicable. So the answer is no. So whether hybrid system is applicable to compute income under income tax act. What is meant by hybrid system? Can you tell what is hybrid system in income tax? There is a cash system. There is a mercantile basis system. What is hybrid system?
One on cash and another one on what do you call receipt basis.
What is one?
All receipts on cash and all expenses on accrual basis.
Yes. So you should not give one on receipt, one on journal. You see expenses on accrued basis you can calculate, and receipts are on cash basis. This system is not applicable in India. This type of system is called as hybrid system. Ram has paid 25,000 as cash expenditure in cash. Can he claim that expenditure against his income? No. 48(3) cash expenditure is restricted to 10,000. Yes, he can claim because he has spent the amount in cash. So any amount exceeding 10,000, then it has to be paid only in account pay check or DD or RTGS. Otherwise, that expenditure will be disallowed and you cannot claim that expenditure as a deduction. So the answer for the question number 47 is no. The answer is 47A. It is not 20,000. Sir, Purushottam sir, where are you? I think I am missing you. You have gone back. Gone back to the second list. 20,000 is decreased to 10,000. I think
Okay.
when we wrote the income tax paper, it is 20,000. Now it is 10,000.
Right, sir. Thank you.
Okay.
Thank you.
20,000 is correct. As I say, when we wrote the examination in the year 1983-84, assessment year. But it's the transport charges, yeah, that is 35,000, up to 35,000 it is allowed. If it is transport charges, Vijayalakshmi, you are correct. If it is transport charges, up to 35,000 you can claim. Personal expenses, capital expenditures, fine, penalty for infringement of the same will be allowed as expenditure. No, it will not be allowed because personal expenses, capital expenditures are not treated to be expenditure. So it is not allowed. Presumptive income. Mr. M has shown a of 10%. Is he entitled to claim his return to be filed under section 4480? Yes. It is more than 8%. So he can claim deduction under section 4480. The answer is yes. This is a regular question in the examination. Money received on maturity of LIC policy. Is it cash or receipt? Revenue receipt, capital receipt, or deposit receipt? C, capital receipt, capital receipt. C, yeah, it's a capital receipt. So the answer for the question 54 is C. Money received by an individual under accident claim. Revenue receipt, capital receipt, cash or receipt, professional receipt. Money received accident claim. It is C. Actually, it's a capital receipt. It's not a cash receipt. It's a capital receipt. So it can, because if you say if it is a capital receipt, it has to be shown under other sources. So you have to pay income tax. So it's a capital receipt. It is not liable for any taxation. Unabsorbed depreciation can be carried forward and set off for a period of 4 years, unlimited period of 8 years and 10 years. Unlimited, yeah, B. Unlimited, yeah, it's unabsorbed depreciation. You can carry for a period of, any unlimited period you can carry forward. Family pension is taxable under what head? Income from salaries.
Other sources.
Other sources not taxable. C, it is other sources. Sir, you said A, income from salaries. Family pension, sir. Family pension has to be treated as other sources. It has to be taxed. It has to be included in the other sources. Pension received by government and private employees is taxable under what head? Pension. Just see, it is a pension received by government employee and private employee. Is it income from salaries, other sources, business income, or none? It is income from salaries. Okay. None now. Vijayalakshmi ma'am. It is income from salaries. It's a pension. Because there is an employer-employee contract, so it is taxable under income from salaries. Income from farmhouse has to be, in an agricultural land, so farmhouse is there. Whether you have to show that income as under property, agriculture income, other sources, or business. A farmhouse is there. For that, you have already received a house tax receipt, and at which head you have to charge. Govardhan said it is income from agriculture. It is B, because it is not, it is a part of agricultural land. Farmhouse is a part of agricultural land. So it has to be covered under income from house. That is agricultural income only you have to consider. Now there's a latest concept here. People say you are not resided in the house property, that is in the agricultural land. You want to get the benefit of agricultural land. Now people, they used to construct some 3 or 4 different farmhouses in their land, and they are letting out that agricultural farmhouse on rental basis on weekend. So where to charge that rental income? So it's a farmhouse constructed in a agricultural land. Where to charge? It's a greenhouse concept. There's a latest trend. Now it's in market. It's a greenhouse concept. So I am not going to any agricultural land. I am not having any agricultural land. Just like going and staying in resorts, they have constructed a farmhouse in the agricultural lands. They are letting all the property on rent. On weekend, we used to go to that agricultural land and stay in that farmhouse for a day or two. They are charging some 2,000 rupees or 3,000 rupees per day. When family we are going, where to charge that rental?
Business income, sir.
Farmhouse. It is not an income from house property. It's a farmhouse rent. So farmhouse rent, you have to treat it as agricultural income. So this is not a business expenditure. LIC payment, Bhuja, interest on capital, and all the above. For the 61 question, the answer is, this is not LIC payment, it's not a business expenditure. Puja is not a business expenditure. Interest on own capital is not a business expenditure. All the above is the answer. Interest paid to partners can be deducted, not deducting if authorized by the deed to the partnership to the extent of 6%, 10%, 12%, 80%. It is C. So to the maximum of 12%, it is C is the answer. A person transfers his movable property to his wife, to his spouse to live apart. Whether clubbing provisions is applicable?
No.
No, yes, not certain, partly false. To live apart, yes, given the property. Whether clubbing provisions is applicable? No, because she's not his wife. He is not her husband. So clubbing provisions are not applicable.
Sir,
Sense it has to be kept. Father, yes.
sir, in the previous question, okay, in that case, that clubbing provision is not applicable, but will it be taxable under other income? Because he is not a relative.
I said it's not a relative. No?
That is what any amount transfer.
Given divorce. No, someone has given divorce. Then can you club that wife's income, that is divorcee income to you?
No, sir. But whatever the value of property that got transferred, will it be taxable in the hands of wife? Because she is no more a relative under 56.
No, she's not a wife. She's not a wife.
So under 56, it will be taxable, sir.
It's a clubbing only. So you can do it, but not under clubbing provisions. Minor's income is to be clubbed in whose hands? It is the parents whose income is higher, you can club it. Bank deposit interest 50,000 is received by Mr. Kumar, who is a government servant, under which head this bank interest has to be charged. Any bank interest, it has to be treated as income from other sources. So though he is a government servant, the bank interest has to be charged under income from other sources. Lottery and gambling income is taxable at regular slab, flat 5%, flat 20%, or flat 30%. It is flat 30% you can charge. Arrears of salary, under which head you have to charge, whether any relief is available to the salary employee. 89.1, 80C, 54.10. Yes, it is 89.1. And in Tamil Nadu now we are having one, it's not a problem. Now a group of salary employees, they received arrears for 32 years. So you have to work out for 32 years, 89.1 relief. But the tax saved will be around 70 to 80,000 rupees. But it's all salary. When he asked 5,000 rupees, they said, sir, we used it, but it's very, very difficult. But this in Tamil Nadu, that's the arrears of salary they have paid. See, in this, now I am master in 89.1 relief, and now I am able to do a lot of transactions. But when I started my practice, I don't know how to do this 89.1 relief working. I lost some 70 clients of a very big college. Suppose if I worked out, I would have received some files, but I lost the entire client because I don't know how to calculate 89.1 relief. Now I am very strong, but I am not having that clients. So please, suppose Arun sir, if you are an youngster, be master in 89.1 relief, because all government employees will come and approach you. Another area wherein you can practice is ATP. Yes. You know, income from cooperative societies, you have to practice. All chartered accountants, you can practice in filing the ATP cases. All cooperative society cases you can get. And where to get the files? You have to go to the society registrar. There you can get the lead. You can do the practice. Advance salary, which year it is taxable? Year of receipt, year of applicable, when it is due, as decided by CIT. Advance salary you have received, which year it is taxable? The year of receipt is the year in which you are receiving advance salary. You are liable for the taxation. 87A, calculation up to 3,50,000. What is the rate? 5% to the maximum of 2,500, 10%, 20%, 10%. Is A. Okay, I'm here because another 40 slides are there. I'll stop because for want of time, I'm just stopping this presentation and I'll share this. It's a very, very important thing. You can go through this, this PPT. Maximum extent, you try to attempt. Don't see the answer. You try to attempt. Even if it is wrong, you refer that, you can do it. So because PPT I'm sharing it, it is not in PowerPoint. It's that is PowerPoint I'm sharing it, and not in that is also in other mode. I am not sharing. I'm sharing with all the PPT. You just click it, you enter it, you just try the answer. Here I am going to teach you. I'm going to stop the presentation here. And already I said I'm going to teach you how to do fraud. And so only one case I want to discuss for the sweet memories and closing area. How to get loan from 5 banks based on only one document. Sharda, I think you can share your experience. How you helped your client to get the loan from 5 banks based on only one document. Can you share?
That would be the CMA and the balance sheet of the company. CMA.
Forget this ad, forget income tax ad, all act you forget. Now you have to get a loan from a bank, from 5 banks based on only one document. I am having only one title deed, only one stamp paper I got. I want to get loan from 5 banks. How to do it?
Is it MSME registration?
It's all KYC you are talking. Shalini ma'am? Have you heard about this? I think Govardhan sir has got, Purushothaman sir is a senior. I think you have got a lot of experience in it. How to get loan from 5 banks based on only one document?
No, I am not in that field.
Okay, I'll just, I'm going to explain. See, this I have found out in my audit. This, I think I have found out more than 92 frauds, different type of frauds I have found out in my audit area. So I'm in practice since officially from the year 1980, from the year 1986. That is, I have got almost official practice of 34 years. But I used to practice. I mean, I have already started my practice in the year 1983. 1983, I started my practice as a consultant. Then I cleared the examination in the year 2000. I mean, the year 1986. After that, I got a lot of bank audits. See, I went to a bank audit. I have found out one tip, different type of section. Here, the father has spent, can you see my hand? So this you can easily understand. Father has received a loan amount from a bank by mortgaging his land. Say, let us take survey number 57. In survey number 57, he has got a loan from a bank. After 1 year, say after 1.5 years, what he did, he has divided his land into 4 parts and has gifted the property to his 4 sons, 57 bar 1, 2, 3 and 4. Now how many documents are there? 4 plus 1. For the first document he has received from the bank. Then these 4 sons, they have approached the bank. 57 bar 1 goes to the first son. He has gone to say X bank, then he has availed. So when the legal opinion, for the legal opinion, when you apply for the encumbrance certificate, the encumbrance certificate says there is no encumbrance because the encumbrance is for the survey number 57 and not for survey number 57 bar 1. So this son has got loan from A bank, another one B, another one C and another one D. How is it possible? So when you are going for audit, or when you even suppose if you want to buy a land or if you want to buy a property on your own, please be careful. If the property is acquired through gift settlement, in the gift settlement there is one sentence called since I am having some other property, I have not handed over the original document to you. I have handed over to you only the copy of the document or Xerox copy of the document. In that there will be wordings in that gift settlement. So what they did, they got the loan from 4 banks. So father has got loan from 1 bank. All the 4 sons on the same property, they have got loan from another 4 banks. So totally 5 banks, from 5 banks, they got the loan. So based on one document, they availed loan from 5 banks. This is the first example. What I have found out is I asked say I have gone for the son number 2, 57 bar 2, I went for the audit. So when I happened to see that, then this person, I asked him, can you provide the original document number 57? The son, without knowing the seriousness of the transaction, he said, no, this original document is with my father. He has availed loan from some other bank. Then how you avail this loan? I said, he has gifted the property to me, I have availed it. So in this manner, I have found out this type of fraud. The fraud, because they have received from 5 banks, the total fraud of this transaction crossed more than 2.5 crores. So entire document, entire 5 banks, they have recalled the loan. So this is one thing. Another thing, another important thing which you have to follow in your lifetime is, say I went for the inspection audit of your bank. Say it is, it is A bank. I went there, then the manager took me to the unit. That borrower, he has received me well. The borrower name is Buvaragasamy. Just see, when you go to the inspection, you have to see the borrower name. The borrower name is Buvaragasamy. Okay, he received well. He has given me a tender coconut and all units he has took me and he has shown to me. Then after 1.5 months, I went for another branch audit, another bank audit. As a revenue auditor, I went there. Here I went as auditor. There I went for the revenue auditor. Then on seeing the papers, I used to see the borrower's name. I used to see the borrower's name. There also I found the name of the borrower as Buvaragasamy. See, this Buvaragasamy has availed loan from other bank. Now the same person is coming here and has availed the loan. Then when I asked for the document, I found that the loan is being given based on the partition deed. So when there is any partition deed, normally there are 4 brothers are there. Himself, Buvaragasamy, another 3 brothers. All the 4 documents were with Buvaragasamy. Then what he did, he has given his brother's document to this bank and he has availed the loan. So again, I asked the manager, sir, can we go for the inspection? The manager said, no, you don't go for, we will not go for inspection for the revenue audit. Then I said, no, we have to go for the inspection. Then I narrated everything. Then he took me to the unit. Then there, on seeing me, that Bhuvarasamy has ran away because he came to know that I have found out the mistake. Okay, then I took this manager to the original bank. Then they discussed and both of them have recalled. Then after 2 months, I went to another bank audit as stock auditor. There also I found the name of the Bhuvarasamy. There also same exercise I did. Then I took this manager to that person. Then again he ran away. So based on the partition deed, one partition deed, he has availed loan from 4 banks. The total amount exceeded 4.5 crores. This is a one exercise. Then I went for the statutory audit of a private sector bank. There is a limited company. The company name is, the company name is Arthur Steels Private Limited. That bank has given loan to the tune of 7 crores. So if it is a 7 crore as a chartered accountant, as a statutory audit, I have to go thoroughly. Then I have gone thoroughly. There also I have found out the name of Bhuvarasamy as the managing director. And his 3 sons were included as director of the company. Then, okay. Then I turned the documents, and one side of the document, on the one back side of the document, I have found out a court seal. Then I asked the manager, sir, a court seal is there. That means this document has already gone to the court. What is the matter? Then he was a new manager. He didn't know anything. So then he asked me one day time. Then what he did cleverly, he went to the spot. Then he inquired about the local banks. And they say that, so this property is being mortgaged to us. That bank has said, so this property is a cinema theater property. So this property is with us. This we have already filed before the DRT. The DRT document is now with another bank and he has availed the loan. So then he made a depth inquiry. Then the manager, that Bhuvarasamy said, sir, we went to that court and we have given copy of the document and we have taken the original document. This will not be possible because in court they are not supposed to give back the document. So as a chartered accountant, as a statutory auditor, I have found out this fraud of 7 crores in that. So this is a thing, when one document you can get any number of loans. So even some extent I used to say that a legal opinion, can a legal opinion be referred or relied? This you can say. Legal opinion is that, can a legal opinion be referred or relied? Govind sir, you can share your experience. I think
it has to be referred, sir.
Referred.
Relied means because actually where there is an apparent mistake in whatever we do, like we are able to find out.
So, see, legal opinion is being given by the panel advocate.
Yeah.
Another question, can a chartered accountant or can an inspection official question the authority of the advocate? This is another question. So my experience in this, a legal opinion can be referred, but it can be referred by the branch, by the bank, and not by the chartered accountant. One. Second thing, we are not questioning the authority of the advocate, but we are just the points which have not been covered by the advocate. In one of the same thing has happened in private sector bank. They had a very big discussion in the board. They had very big discussion. I went for as a content auditor. I questioned and I pointed out the mistake of the advocates. And the board said, that is the GM of that bank, they said, no, as a chartered accountant, as a content auditor, you are not supposed to question the authority of the advocate. Then I said in the appointment letter, you say that you have to verify the legal opinion. Why you gave this direction? You just remove the direction, then I will not comment. Then it went to the board. Then RBI nominee, RBI director said, No, auditor is that whatever comments he gives, you have to accept, and you see the genuineness of the comment. If it is genuine, you have to act accordingly. Otherwise, you need not consider that. It is the right of the auditor. You should not, as a GM, you are not supposed to question the authority of the auditor. Though you have given the appointment of the auditor, you are not supposed to question the authority of the auditor. There are a lot of disputes like this. And I want to share, see, if you are doing any audit, if anyone objects to your audit or anyone disturbs the audit, then that means there will be some fraud. So a fraud is fraud. I said a fraud is a very big area wherein you can do a lot of, you can get a lot of experience in it. This is all my thing. And actually, I've released YouTube on bank audit. 81 videos so far I have released, and it's being welcomed by almost all chartered accountants in all parts of India. And I am proud to say that I've got a lot of fans in this. A lot of students also, they used to give comments. It's a very good area. Suppose if any member wants to specialize in any particular area, you be a master in releasing the YouTube, so that you'll be a master, you'll be needed by everyone. And with this, I'm any doubt or anything you can ask, because when you ask me to talk about bank audit, I can handle for 6 to 7 hours, and that too in last experience. I want to, with the conclusion of only one experience, I want to conclude. I went for a statutory bank. I have found out a fraud of 87 lakhs in jewel verification area. Lot of ornaments missing, lot of irregularities there. Then I reported that 87 lakhs value of jewels as fraud. Then team from head office, team from Reserve Bank of India, they came to the bank based on my report. They have inquired, they called the jewel appraiser. Then the jewel appraiser, they verified the entire jewels. They came out conclusion to the tune of 1.48 crores have been cheated, and not as 87 lakhs. I used to say that on test check basis, I have found out this fraud of 80 on test check basis. So I given a qualified report. Then 1.48 crores have been found under the fraud. Then they call the jewel appraiser. Then jewel appraiser, he was not able to give the answer. See, a lot of basic things have gone. Why I disturbed the jewel appraiser means when I entered the branch for the first time, he came to my cabin and said that, sir, do you need coffee or tea or cool drinks? This is the first question he raised. Then I asked him, who are you? He said, I'm the jewel appraiser. Why you ask this question? Sir, anyone who comes to the audit, I'll be taking care of everyone. Then I'm not a beggar man. You go there, I'll take care of my audit. Don't interfere in the audit. Don't enter into my cabin. I changed the entire audit program to verify the entire jewels. So there I have found out 87 lakhs. Then this appraiser is being called by the Reserve Bank of India official and the bank head office. See what has happened. He said, sir, I'll go for lunch and come back. This is the thing they said. They told to the manager. To the Reserve Bank official. They said, okay, it's a lunchtime. You go and come back. He went there by around 2:15. Then up to 4:15, that appraiser has not turned up. Then this Reserve Bank official said, where is the appraiser? They asked, where is the appraiser? Then this manager has sent his substaff to the residence of the appraiser. There he found out that that appraiser has committed suicide. It's a very big experience, because based on my audit report, someone has endorsed, and this appraiser has committed suicide. It has come in media, it has come in newspapers and everything. Even lot of public, they went to the bank and they want their jewels back. So my question is, you are a professional, you have reported a fraud. Based on that appraiser has committed suicide. In my area, few chartered accountants who are very close to me, they say that only because of your report, he has committed suicide. Can a chartered accountant be liable for it? Suppose Sharda or Shalini said, based on your report, someone has committed suicide. Are you liable for the acts of the other person? So a chartered accountant
No.
as an auditor, you are there to report. That's all. You
That's
need
all.
to bother about the other
Working in
happening.
your professional capacity.
Huh?
So you are working in your professional capacity. The outcomes are not in your hands.
Not clear.
I'm saying you are working in your professional capacity. The outcomes are not in your hands.
Yeah.
It's
Any person, we are all professionals. Whether you are a company secretary, cost accountant, or chartered accountant, we are all professionals. Our goal in that the report is being made. That's all. After that, you need not bother about anything what is going. This is my opinion. And all my friends, they say that no, you are a guilty person. You are responsible for his suicide. No, I will not bother. Let him go to hell because he cheated the public, he cheated the bank. So I am not bothered about what has happened. So this is the thing I want to share. And if you want me to present for more frauds, I can present, but it's almost we have crossed the time. You have to take rest. And I think for Sharda and Shalini, I gave 2 assignments. I will definitely will not leave you. Please share your experience on those points.
Sure, sir.
30. And another thing, 2 years, 30, 60, 90. Arun, I think you can say what's the second area? Even I have forgotten that. Okay, anyhow, tomorrow I'll
one
put it
is
in the
30,
WhatsApp
60,
group.
90.
Huh?
Okay. Okay, sir.
What is 60? What is 90?
No,
Okay,
I'll come back to you
I wish you all the
definitely.
definitely because we, not only me, because it is useful to all members, everyone.
Right.
Because you are going to be the valuer. I want to give one suggestion because you are all parts on all parts of India. You are there. Okay, why don't you form a unofficial partnership? It is not official partnership. Unofficial partnership. Why don't you form among the participants? It is don't enter into official partnership. Suppose if you have got work in say Pune or if you have got work in Calcutta, you can give to Sharda. Let her do it, but don't leave any job. Correct? Suppose if you are in Chennai, you assign the work to Chennai Chartered Accountant, and Purushothaman sir is there in Mysore. You give the assignment to get the papers. You go to Mysore and they ask Purushothaman to take the zoos and everything in Mysore. The tourist part. You can ask Purushothaman sir to take everyone to the tourist part. But and my request is, we you can form a separate unofficial. It is not official partner. If you are doing unofficially, okay. But when you get the work from various parties, various persons, you can share your work. One second thing, my suggestion is you have to have close contacts with the insolvency professionals, wherein you will get lot of works. Because though I am an insolvency professional, I am not in the panel, but I used to have very good contacts with the IPs. They used to send the files to me as towards the valuation. So after clearing the examination, you must do this exercise so that you will get more fines, more income from it. And also I said two courses that you have to study. One is ACFI, second one is import and export procedures. In import and export procedures, particularly if you are from Delhi, you can have one license called DORA Gold, DORA. Even anywhere you can practice DORA, DORA Gold. It has to be issued only by DGFT New Delhi. The minimum fees I heard from the Delhi Chartered Accountant is 25 lakhs is the minimum fees to get that license. 25 lakhs. So that includes everything, fees and all adjustments amount that is inclusive of that 25 lakhs. But and mint money in practicing in Dora gold. So because gold is not allowed to be imported into India, but by Dora gold is a waste particles of gold mines. You can import the wastage or sand from the gold mines from other countries. You can separate sand and you can take the gold parts separately, then make a coin or make a biscuit and everything. It's a very big area wherein you can practice. So that's why I said DGFT in import and export, that gives you a lot of business. And wish you all the best, and I'll see you as a valuer soon. And
Thank you,
you
sir.
push you to become a faculty along with me. And sometimes you can overtake me because of your knowledge, because of your influence,
No, sir.
or we can influence in knowledge and influence, I mean, fluency in English. Because I am not English, because I study in Tamil medium. If you want me to talk in English, I can speak in English only with reference to the studies, I mean, the subject.
Studies only.
And you are well versed in knowledge. You are all youngsters, because almost I am reaching the other part. That is almost 2/3 of 100 years I have crossed. Not 2/3, 2/3 of 90 years I crossed. I'm just 61, and so I've got some planning. Okay, you are all youngsters. Purushottam sir, I'm not meaning you. You are all youngsters. You are part of me.
Young by
Thank you,
heart.
sir, for such an interactive session. And we are really, we have got so much kind of information in all kinds of fields, not just the topic we are studying only. So it's a experience of a lifetime kind of.
Having of experience. That's why I said why I insisted Sharda and Shalini to, to give the participation. We need your experience. You may be a master in your area.
I get
So, talk in bank audit, I can proudly say that I'll be number one in bank audit presentation. No one can beat me, because that much of experience I got, but it is not out of, what's that? It's my experience I want to share. That's all. I want you to learn that experience. That's why I said how to get loan from 5 banks based on one document and partition deed. Not have experience of that, and please qualify in ACFE, ACFE. I think all company secretaries, cost accountant, chartered accountant, they can qualify. See, one chartered accountant from Guntur is aged about 24. He has cleared ACFE. His minimum income, that is his salary. Yes, now at present he is receiving around 4 lakhs per month. 4 lakhs per month. He has become employee of that company. 4 lakhs per month he is receiving at the age of 23 years. So this is also a very big area wherein you can practice, and I wish you all the best. And anyhow, I will meet you through WhatsApp group soon. Thank you very much.
Yes.
And if you got any doubt,
Thank you, sir.
Sure, sir. Thank you.
Thank you,
Thank
sir.
you, sir.
yes, sir. I think Manmohan Sharma, sir, so far I have not seen you. You came and I think it's not there. Okay, anyhow, thank you very much. Vijayalakshmi madam, thank you. And Gopal sir, Shalini ma'am, and Manasi, Purushottam sir, Arun sir, Sharda, and
Thank you,
Shalini.
sir.
Thank you very much.
Thank you,
Thank
sir.
you,
Thank you very
sir.
much.
Thank
Thank
you.
you. Thanks a
Great
lot.
interactive session.
Thank you.
No, when other faculties they are taking class, I will come silently, because I can watch
Anytime,
the
sir.
proceedings. Okay. Thank you very much.
Bye, sir. See you. See you.
Bye,
See you.
sir. Bye.
Thank you.
Bye, sir.
Bye.
Have a good night, sir.